Court observer. Court observer.
I am in now added in the panel. Add my name. ಮಾಡಬಹುದು ಬಟ್ ಮೇಡಮ್ ಒಂದು ಲಿಸ್ಟ್ ಇಟ್ಕೊಂಡಿತ್ತಲ್ಲ ಯಾಕೆ ಬರದ್ರಿ ಏನಂತ ಕೇಳಿದ್ರೆ ಅದ್ರ ಬದಲು ಅಯ್ಯೋ 25 days ಇದೆಯಲ್ಲ ಸರ್ ಇನ್ನೂ ಮಾಡಿಸಿ ಅಷ್ಟೇ.
Sir, court observer.
ಹೇಳಿ
ಸರ್
ಸರ್.
ನಿನ್ನೆ ಒಂದ್ ಮ್ಯಾಟ್ರ್ ನಿನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ದೆ ಮೇಡಮ್, ಇವತ್ತು ಬಂದಿಲ್ಲ. ಅದ್ ಮತ್ತೆ ಮೂವ್ ಮಾಡ್ಬೇಕಾ ಅಥವಾ
ಸರ್
ಡೇಟ್
ಡೇ ಆಫ್ಟರ್
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಟುಮಾರೋ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್ ಎಲ್ಲದಕ್ಕೂ.
ಓಕೆ ಸರಿ ಮೇಡಮ್,
ನಾಳೆ ಬರುತ್ತೆ.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ನೆಕ್ಸ್ಟ್ ಡೇ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಬರೋದಿಲ್ಲ ಈಗೆಲ್ಲ ಮೆಮೋಸ್ಗಳು.
ಓಕೆ ಮೇಡಮ್, ಐ ಗಾಟ್ ಇಟ್, ಥ್ಯಾಂಕ್ ಯು.
ಎಂಟ್ರಿ ಆಗಿದೆಯಂತೆ. ಹೌದು ಹೌದು, ಅಲ್ಲ ನಂಗೆ ಗೊತ್ತಾಯ್ತು ಅದು. ಇವ್ರ ನಾ ರವಿ ಫೋನ್ ಮಾಡಿದ್ದೆ, ನೋಡ್ಕೊಂಡು ಹೇಳ್ದ ಅದು ಅಲ್ಲೂ ಬರೋದಿಲ್ಲ, ನಮ್ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ಬರ್ತದೆ ಅಂತ ಹೇಳ್ದ. ನಮ್ಮ ಆಯ್ತಾ, ಅಲ್ಲೇ ನೀರ್
ಮೇಡಮ್ ಎಲ್ಲಾನು ರೀಚ್ ಆಗುತ್ತೆ
ಅಷ್ಟೇ. ನೀವಲ್ಲಿ ಹೋಗಿ ಇದ್ ಮಾಡಿ, ನಾನು ನೀರ್ ಫುಲ್ ಡನ್ ಅಂತ ಹೇಳ್ತೇನೆ ಇದರಲ್ಲಿ. ಅಡ್ಡಿಲ್ಲ ಅಡ್ಡಿಲ್ಲ ಅಡ್ಡಿಲ್ಲ, ಹೇಳ್ತೇನೆ. ಕೊಡ್ತಾರೆ 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 ಕೊಡೋ ವ್ಯವಸ್ಥೆ ಮಾಡ್ತೇನೆ. ಆಗಿ ಸಾಹೇಬ್ರು ನೀವೇ ಬನ್ನಿ, ಕ್ಲರ್ಕ್ನ ಕಳಿಸ್ಕೊಡಿ, ನಾ ಕೊಡ್ತೇವೆ ಫೈಲು, ಇಲ್ಲಿ ಡೈರೆಕ್ಟ್ ಕಂಪ್ಲೈ ಮಾಡ್ಬಿಟ್ರೆ ಕಳಿಸ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆಯ್ತಾ? ಸರಿ, ಓಕೆ ಓಕೆ ಓಕೆ.
Last week of next month ಇದೆ. ಅದನ್ನ ನನ್ನ ಕೇಳಿದ್ರೆ ನಾನು ಇದ್ದೆ ಆಕ್ಚುಲಿ ಅರ್ಜೆಂಟ್ ಅಂತ ಕನೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಬಿಸಿಲಿ ಮೆಮೋಸ್ ಮೇಲೆ ಹೋದ್ರೆ ಹೌದು, ನಾನು ಮೆಮೊ ಮೆನ್ಷನ್ ಮಾಡಿ ಮೂವ್ ಮಾಡ್ತೀನಿ ಮೇಡಮ್. ಇದ್ರಲ್ಲಿ ಅವರು ಡೇಟ್ ಹೇಳಿದ್ರೆ ನೋಟ್
ಏನೋ ಬರ್ತಾ ಇದೆ. ಹಲೋ ಕೊಟ್ಟಾಪ್ ಸರ್, ಕೊಟ್ಟಾಪ್ ಸರ್, ಹಲೋ ಹಲೋ ಕೊಟ್ಟಾಪ್ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮೇಡಮ್? ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಹೇಳಿ ಸರ್.
ಓಕೆ ಮೇಡಮ್. ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಅನ್ಸುತ್ತೆ. ಬರ್ತಾ ಇಲ್ಲ. ಈಗ ಬಂತು. ನಂದು ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ? ಈಗ ಯಾರ್ದು ಬರ್ತಾ ಇಲ್ಲ.
This case, my lord, date given for the next month end, my lord. There is a urgency of withdrawal of amount ಅಷ್ಟೇ. ಇದು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ, ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ವಿಡ್ರಾಲ್ಗೆ. kindly list it for tomorrow, my lord. ಅದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಂದ್ರೆ ಒಂದೇ ಆರ್ಡರ್ ಮೇಲೆ ಬೋತ್ ಪಾರ್ಟೀಸ್ ಹ್ಯಾವ್ ಪ್ರಿಫರ್ಡ್ ಅಪೀಲ್. ಸೇಮ್ ಆರ್ಡರ್ ಮೇಲೆ ಅದು ಒಂದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ದಟ್ ಇಸ್ ಇನ್ ದಿ ಡಿವಿಷನ್ ಬೆಂಚ್. That is in the division bench, my lord.
The matter was called on 29/8.
29th,
Why you
my
have
lord, I
not
appeared
requested?
through VC, my lord. Suddenly matter was urgent. I mentioned, but my lord, there is an urgency of withdrawal of amount. I filed IA for withdrawal of amount. That is the urgency. Swami, our call imputation agide, leg imputation agide. Kindly tomorrow, my lord.
Not tomorrow, Mr. Counsel, you give it, it will be posted.
Any next Wednesday at least.
Yes.
Next Wednesday.
My lord,
Don't give the date, they'll post it.
Oblige.
Yes.
my lords, in this case, interim order is necessary. The respondent has already filed execution petition, and I being the tractor owner,
Yes.
kindly tomorrow or
Which year, of which year?
2024.
Yes.
Fresh matter, man. Fresh matter for notice.
But posting for stay.
Yes. Adjournment, page wise. Page number 8. Serial number 31 to 34. Page 9. Serial number 35 to 41. Page 10. Serial number 42 to 46. Page 11. 47 to 51. Page 13. 52 to 55. Page 14. 56 to 60.
My lord, serial number 59. Kindly adjourn 2 weeks. I'm appear for appealant.
Your good name, Mr. Counsel. Your good name.
Ganesh.
Sri Ganesh, representing Sri Nagaraja Hegde, Land Counsel for the appellant, seeks time. Hence, stand over to 30th October.
One
Serial
submission,
number.
my lord. Serial
Yes.
number 58, my lord.
Yes,
My lord, in this case, I have not received the appeal memo, my lord. In fact, I have been trying to call him, not to getting the receiving the phone also.
we'll see when the matter is called, when the advocate
58, my
appeals.
lord. 58, yes.
Yes,
I will give the copy, my lord.
why you have not given?
Already given, my lord.
No, my lord.
Sri D. Vijay Kumar appears through VC and submits that he has not received the copies of appeal papers. Full stop. Appellant to serve copies of appeal papers immediately.
Today only I will
List
collect it,
on-
my lord.
List on 25th September.
Serial
Much
number
obs-
57, my lord. 57,
57.
1 week price time, my lord.
Why?
Senior is inconvenience.
Huh?
Senior is inconvenient.
Your good name.
Rohan, my lord.
Huh?
Rohan.
Sri Rohan, representing Sri Tejas, Land Counsel on record for the appellant seeks time. Have you informed the other side?
I will inform, my lord.
We don't mention without informing. Next.
My lord, serial number 62, my lord.
Yes.
I have received the copy of the appeal memo and also send it to the insurance company. They are sending the wakalat, my lord, in serial number 62 and 64. Kindly call this matter next week. We can go on with the matter.
62.
And
Sri
64.
D. Vijay Kumar, Sri D. Vijay Kumar appears through VC and seeks time to file wakalat. Time for 2 weeks is granted. Released on 23rd October.
Much of it. Like 64 also, my lord.
64, we'll see, Mr. Counsel. This is 2021 matter. We'll see when the matter is filed. Next.
Or if you lordship permit me, I'll go on with the matter also. I have informed the.
Let us see. Next.
Page 16, serial number 66 to 70.
63, my lords, 63 and 63.1.
Yes.
So senior inconvenience, press time.
This is 2021 matter, Mr. Counsel.
We have informed the other side.
Next.
List 1, serial number 1, this Syed Abul Sabur.
I am for appellant. Today only I have done, my needful done, my lord. Paid the amount as well as taken the steps also.
Learned Counsel Sri Syed Abdul Sabur submits that he paid costs of rupees 500 as ordered and also furnished the requisites. Full stop. Registry to verify, full stop. In case requisites are not furnished, office is directed to send notice to respondents 1 to 3. List on 13th November.
Serial number 2, Srimati Harini Shivananda.
I appear for the appellant, my lord. I need 2 weeks time to take steps to bring a loss and record. My lord. A loss of our to insured, my lord.
When we received the intimation that R2 died,
7/8/2024, I believe. On that day when the matter was listed, it was
we received intimation on 26/5/2022, Amma.
but when the matter came on 7/8/2024, I was informed that he is dead, my lord.
We'll dismiss the appeal against R2 as abated, Amma. If you take steps, you file, you move necessary application.
Yes, my lord.
Heard. Harini Shivanand, Learned Counsel for the appellant who appears through video conference. Full stop. Steps to bring the legal representatives of respondent number 2 are not taken. Full stop. Hence, the appeal is dismissed against respondent number 2 as abated. Full stop. Admit. List the matter under the caption final hearing on 23rd October.
Much ado.
Serial number 3, Sri Pawan Chandra Shetty.
I'm for appellant, my lordship. Memo for dispensation filed, my lordship. And kindly take notice may be issued, my lordship. Insurance companies.
Your good name, Mama?
Akshaya.
Heard. Miss Akshaya, who represents Sri Pawan Chandra Shetty H, Learned Counsel on record for the appellant. Memo seeking dispensation of notice upon respondent number 1 is on record. Why it should be dispensed with?
Because liability is fastened on, fixed on the insurance company, my lordship.
Learned Counsel Miss Akshaya submits that as a liability is fastened against respondent number 2, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, notice to respondent number 1 stands dispensed with. however, at the risk of the appellant.
Insurance companies, SBI General Insurance, my lordship, kindly take notice may be issued, my lord.
Sri B. Pradeep is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks.
Please, my lord.
Appellant to serve copies of appeal papers at the chambers of Sri P. Pradeep. List on 6th November.
Yes.
4, Shri R. Shashidhara, Muralidhar Negawar.
1 week accommodation, my lord.
This is 2022 matter, Mr.
My
Counsel.
lord, the client petition dismissed case, my lord. We will take steps, sir.
Sri Rangegowda.
Please.
Rangegowda representing Sri R. Shashidhara, learned counsel for the appellant seeks time to furnish the requisites. Full stop. Time for 1 week is granted. Full stop. On furnishing the requisites, office to send notice to respondent number 1. List on 13th November.
Much obliged.
CL number 5, Srimati Srividya.
I represent the appellant's counsel, my lord. A memo is filed seeking dispensation of notice to R1. R1 is the owner, my lord. The liability is admitted and the policy is also admitted, my lord. I seek for dispensation of notice to R1.
Your good name, Amma?
Sharada.
Heard. Srimati Sharada, who represents Srimati Srividya GK, and counsel on record for the appellant. Stop. Memo seeking dispensation of notice upon respondent number 1 is on record. Full stop. Learned counsel, Srimati Sharada,
Please.
submits that as liability is fixed upon respondent number 2, comma, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
The second respondent, my lords.
Srimati Geeta Rajpur, respondent number 2 is present. Admit, list the matter under the caption final hearing on 25th September.
Much obliged. Grateful, my lords.
CL number 6, Sripad Vishastri.
Lord, I am for appellant, my lord. I filed a memo for dispensation of notice to R1, is the owner of the vehicle. And there is a delay of 4 days in filing the appeal.
Why it should be dispensed with, Mr.
Because
Counsel?
the liability is already foisted on the insurance company, they satisfied their all.
Heard. Sri Sripad V. Shastri, learned counsel for the appellant who appears through VC. Memo seeking dispensation of notice upon respondent number 1 is on record. Full stop. Learned counsel Sri Sripad V. Shastri submits that as respondent number 2 admitted his liability, notice to respondent number 1 may be dispensed with. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
But I am ready for even.
IA-1 of 2022 is filed, seeking the court to condone the delay of 4 days in filing the appeal. Heard. Sri Sripad V. Shastri, learned counsel for the petitioner appellant. No representation on respondent side. Gone through the contents of the affidavit given in support of the petition. Having considered the ground such, the delay as prayed for is condoned. Yes, Mr. Counsel.
Yes, my lord, if records is arrived, I am ready to go on with the matter.
We list for final hearing. There is no representation on the side.
I thought, okay.
List the matter under the caption final hearing on 18th September. 18th September.
CL number 7, Sithitesh Mumi.
I'm affair for appellant.
Admit.
Sorry, my lord, the previous matter, records is not called, it seems.
Records are required.
Records. Well, records necessary, my lord. So,
Call for the records, list the matter and caption final hearing on 25th September. Yes,
Case of injury,
yes.
memo for dispensation.
Why the notice has to be dispensed with counsel? Why the notice has to be dispensed with?
Yes, madam.
Why it should be dispensed with?
R1.
Huh?
R1 owner of the vehicle.
Why it should be dispensed with?
Liability fix on the insurance company. madam.
Heard, you are Mr. Tippeswamy.
Yes, madam.
Heard, Sri Tippeswamy, BC Learned Counsel for the appellant. Memo seeking dispensation of notice upon respondent number 1 is on record. Learned Counsel Sri Tippeswamy, BC submits that as respondent number 2 admitted his liability, notice to respondent number 1 may be dispensed with. Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Admit, this the matter under the caption final hearing on 23rd October.
Seal number 8, Srimati Sharda N, Sri Anil Shekhar.
I appear for the appellant, my lord. My lord, it's the sole respondent who is no more. I have filed application for bringing the LRs of the deceased on record. And I tried to serve a copy. I could not get him, my lord, that IA copies. And anyway, on the death of the respondent, he ceases to be the advocate because his wakalat gets seized.
But you have to serve the copies.
Yes, I will serve the copy, but
Learned Counsel Srimati Sharda N seeks time to comply the office objections.
please,
Time for a week is granted. List on 25th September.
my lord, I may be permitted to file a memo for as IA number 2 not pressed, my lord, because it's for setting aside abatement. It is in time.
On that day, weeks.
Please.
Seal number 9, Sri Vijay Kumar D.
Hello, my lord.
Hello, producing.
I am for the appellant, my lord. In fact, my lord, I have made submission on the previous occasion on 2 occasions. This appeal may be dismissed, holding that non-maintainable and also on merit, my lord. Your lordship has called for. Kindly, the connected matter certified copy is going. This is the connected matter. My colleague is producing the document. Arising out of very same accident and judgment, my lord. That is MFA 2904. That is in respect of connected MEC, my lord. In this appeal, my lord, we have taken the that is in respect of MEC 2768. The present appeal is 2767.
Yes.
Amount is also very less. And tribunal has
Heard, Sri D. Vijay Kumar, Learned Counsel who appears through VC. This appeal
filed by Reliance General Insurance.
arises out of the order that is rendered by the Motor Accidents Claims Tribunal, Bangalore, in MVC 2767 of 2020, dated 27/1/2023. Full stop. The appellant is the insurer of the offending vehicle which is involved in the accident. Full stop. This appeal is filed by the insurance company disputing its liability. Full stop. However, on this date, Sri D. Vijay Kumar submits that the tribunal passed a common order in MVC 2767 of 2020 and 2768 of 2020. Giving
Right.
common findings with regard to the liability of the appellant hearing. And counsel also submits that challenging the order that is rendered in MVC 2768 of 2020, the appellant hearing preferred another appeal, that is MFA 2904 of 2020, and that appeal was dismissed by this court on 22nd June 2024
On merit.
on merits, and thus the present appeal does not survive for consideration. Full stop. A copy of the order that is rendered by this court in MFA 2904 of 2023, dated 22/6/2024, is placed before this court through the proxy counsel. Full stop. Having considered the submission thus made by Sri D. Vijay Kumar, learned counsel for the appellant,
Your last may
and
kindly
on
say
going through the
the
findings
judgment is just and
given-
reasonable. Your last may kindly
and on-
say the
Mr. Counsel,
tribunal,
what we have to say, don't say, you may kindly say, don't say what we have to say.
please, my
What
lord.
did you write? Thus made, and upon going through the contents of the judgment that is rendered by this court in MFA 2904 of 2023, with regard to the liability fixed upon the appellant hearing to pay compensation, this court does not find any further grounds for consideration. Hence, the appeal is dismissed without cause.
Amount in deposit may be
The
transferred to
amount, if
the
any, in deposit be transmitted to the concerned tribunal immediately.
much best.
Serial number 10, Shri P. Mahadev Swami.
Yes, sir. For appellant. The respondent number 2 is the owner of the vehicle. The trial court has fixed the liability to the one, first respondent, my lord, in
Her-
panel court.
Sri P. Mahadeva Swami, learned counsel for the appellant. Memo seeking dispensation of notice upon respondent number 2 is on record. Sri P. Mahadeva Swami submits that as a liability is fixed upon respondent number 1, a notice to respondent number 2 may be dispensed with. Having considered the submission thus made, notice to respondent number 2 stands dispensed with. However, at the risk of the appellant. Is there any standing counsel for Liberty Videocon General Insurance Company?
Ravi Samprati.
The Pradeep B is called upon to accept notice for respondent number 1 and file wakalat subject to entrustment of the case otherwise by respondent number 1. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers, appellants to serve copies at the chambers of Sri Pradeep B. List on 30th October.
3 minutes.
Serial number 11,
Appear for appellant, my lord. Prefer weeks time to taking steps to R1, my lord.
Land Counsel Sri Mahadeva Swami for appellant seeks a week time to furnish the requisites. Time as prayed for is granted. On furnishing the requisites, office to send notice to respondent number 1 in the appeal as well as in IA-1 of 2023. List on 6th November.
Serial number 12. CM English, Jagdish T.
For the respondent number 1 in this case, my lord. I permitted to withdraw the application, my lord, permitted to withdraw the application. Dismiss as withdrawn. That application may be,
Who are respondents 2 and 3?
like that, 1 3 is the owner of the vehicle, my lord, in there are 2 vehicles are involved in the accident.
Respondent number 3 is the,
Owner of the lorry.
any objection?
My lord, I filed the objection, he is withdrawing that application.
That application, dismiss as withdrawn. Dismiss that as withdrawn the application, or permitted to withdraw the filed an application for withdrawal of amount. I may be permitted to dismiss as withdrawn that application.
That application.
That application.
Land Counsel Sri Jagdish HT seeks permission to withdraw IA-1 of 2023. Why you are withdrawing?
But liability and the liability is questioned, my lord, by the insurance company.
Permission as prayed for is accorded. IA-1 of 2023 is dismissed as withdrawn. Yes. Await service of notice upon respondents 2 and 3.
Meanwhile, call for records.
TCN.
Call for the records from the consent tribunal in the meantime. List on 30th October.
Please.
Number 13, SV Agri Mulkun. R1 sir.
The appellant, my lord. Application has been made for paper publication, ma'am. Notice may be issued.
How many times notice was sent?
3 times, I think.
No, Mr. Counsel, only once it was sent.
Take steps.
Mhm. Connected.
Madam, ಏನಂತ madam?
These are not maintainable. You furnish the requisites.
ಏನಂತ madam? Not there ಅಂತ madam.
Heard. Your good name, Mr. Counsel? Sri Rajendra Hegde, Land Counsel for the appellant in both the appeals. IA-1 of 2024. In both the appeals stands dismissed as not pressed. Full stop. Issue notice to respondents 2 and 3 in MFA 580 of 2022 and to respondent number 3 in MFA 598 of 2022 on furnishing the requisites. List on 30th October.
14, Sri M.B. Chandrachud. Rahmatullah Kotwal for R1, Sinkar Reddy for R2.
Appearing for the respondent.
Second is,
Case of injury.
Yes.
there is a delay of 106. Delay may be condoned.
IA-1 of 2022 is filed, seeking the court to condone the delay of 106 days in filing the appeal. Heard, you are Mr. M.B. Chandrachud.
Please, I am.
Huh?
Please.
Heard, Sri M.B. Chandrachuda, Land Counsel for the petitioner appellant as well as Sri, your good name,
Mohammed Akram.
Sri
R1.
Mohammed Akram, who represents Sri
R. Kotwal.
Rahmatullah Kotwal, Land Council for Respondent number 1, and also Sri C. Shankar Reddy, Land Council for Respondent number 2. Gone through the contents of the affidavit given in support of the petition. Having considered the grounds urged, the delay as prayed for is condoned. Yes,
Records may be called for a case of injury.
the records are required.
Please.
Admit, call for the records from the consent tribunal. List the matter under the caption final hearing on 23rd October.
Please. Much of it.
CL number 15, Sri Prithviraj.
R1 is deceased. I filed 3 applications to bring the LRs of R1 on record. R2 is the father of respondent number 1. R2 is the owner of the vehicle. R1 is the driver of the vehicle. R3 is the insurance company.
What about notice to R3?
R3 may take any of the, for the panel advocates, my lord, it is a Reliance General Insurance Company. May be permitted to take notice to any of the panel advocates.
Sri D. Vijay Kumar is called upon to accept notice for respondent number 3 and file wakalat subject to entrustment of the case otherwise by respondent number 3. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri D. Vijay Kumar. List on.
But on the LRs of notice.
Let wakalat be filed, thereafter we'll see. List on 23rd October.
CL number 16, Sri Gopal Krishna, Ravi S. Samprati.
We have opened this case, my lord. It's a case of death, my lord. Date of accident 31/5/2017.
Color. Received the copies are to file wakalat. A week's time may be granted.
Sri Ravi S. Samprati seeks a week time to file wakalat. Full stop. Time for a week as prayed for is granted. On 17th September.
Much obliged.
17, Sri Yogesha GK, Shankar Reddy for R1.
Paper which time? My lord, and serial number 52 is arising same accident, my lord. Kindly post along with.
It is connected.
Why you are seeking time 2022?
On record counsel is not feeling well. On record counsel is not feeling well. Unable to come.
Land Council Sri
P. Mahadeva.
Sri Mahadeva Swami representing Sri Yogesha GK, Land Council for on record for the appellant seeks time. Any objection for condoning the
No.
Ma, you remove that. Where is the record, Amma? IA-1 of 2021 is filed, seeking report to condone the delay of 27 days in filing the appeal. Heard, Sri P. Mahadeva Swami, Land Council, who represents Sri Yogesha GK, Land Council on record for the appellant, as well as Sri Shankar Reddy C, Land Council for respondent number 1. IA-1 of 2024 is filed seeking condone the delay. Gone through the contents of the affidavit given in support of the petition. Instead of having considered the grounds urged, the delay as prayed for is condoned. Admit, list the matter under the caption final hearing on 24th September.
Along with serial number 52, my lord. The arising same accident.
52.
Yes.
52 na 57.
52.
Serial number 52.
What is the national liability?
Third, Sri P. Mahadeva Swami, Land Council, who represents Sri Yogesha GK, Land Council on record for the appellant. Admit, list the matter under the caption final hearing on 24th September.
Macho.
CL number 18. Sri Ravish Benny.
Appear for the second and respondent. In the connected crop, I have to file wakalat, my lord. The
Connected matter?
MFA crop, that is 18.5 to 18.8, my lord. I have to file wakalat on behalf of the insurance company.
Land Council, Sri Ravi S. Samprati, submits that he has to file wakalat for the insurance company in MFA crop 119 of 2023, MFA crop 120 of 2023, MFA crop 121 of 2023, and MFA crop 122 of 2023. Seeks time. Time for a week is granted. Stand over to 23rd October.
18.51, 18.8.
The appellants are directed to comply the office objections. In the meantime, in all the cross objection appeals.
CL number 19.
My
Sri
lords,
Rajesh Yennar.
I'm for the appellant, my lords.
Yes.
So far as my lords, the initial liability is concerned, my lords, it's been fastened on the respondent 1 and 2, my lords. However, the insurance company is allowed to pay on the basis of pay and recovery, my lords. Therefore, I will take steps so far as R1 and R2 is concerned, and request my lords to direct notice to R3, my lords.
Heard. Sri
Shreyas and
Shreyas N, Land Council, who represents Sri Hari Shennar, Land Council on record for the appellant. Sri S.V. Hegde Mulkund is called upon to accept notice for respondent number 3 and file wakalat subject to entrustment of the case otherwise by respondent number 3. Wakalat to be filed within 2 weeks. Issue notice to respondents 1 and 2 on furnishing the requisites. List on 21st November.
Grateful, my lords, grateful.
CL number 20. Kailash Shankar.
Appellant 1. Notice to respondent number 1, dispensary.
Heard, Sri Kailash Shankar PS, Land Council for the appellant. Land Council files a memo seeking dispensation of notice upon respondent number 1. Why notice should be dispensed with?
Liability is fixed against auto insurance company.
Land Council submits that as liability is fixed upon respondent number 2, notice to respondent number 1 may be dispensed with. Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
United into insurance or 2 months.
Sri A.M. Venkatesh called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri A.M. Venkatesh. List on 21st November.
Serial number 21, Kailash Shankar.
Notice to R1 dispensary. And the liability fixed against R2.
Same order, Amma. Heard Sri Kailash.
In this case also United India Insurance.
Srimati Manjula Tejasvi is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Srimati Manjula N. Tejasvi. List on same date.
22, Rangeguda NR.
I am filing the proper dispensation of notice to R1. Yes, the liability fixed against respondent number 2.
Heard Sri Rangegowda NR, Land Counsel for the appellant. Land Counsel files memo seeking dispensation of notice upon respondent number 1. Land Counsel submits that as liability is fixed upon respondent number 2, notice to respondent number 1 may be dispensed with. Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
Second respondent, my lord, SBI General Insurance Company.
Sri Ravi S. Samprati is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri Ravi S. Samprati. List on 21st November.
23, Kailash Shankar.
Appellant for appellant. Notice of R1 dispensary. And the liability fixed against R2.
Heard Sri Kailash Shankar PS, Land Counsel for the appellant. Land Counsel files memo seeking dispensation of notice upon respondent number 1. Land Counsel submits that as liability is fixed upon respondent number 2, notice to respondent number 1 may be dispensed with. Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
R2 is Royal Sundaramans.
Sri H.S. Lingaraju is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri H.S. Lingaraj. List on 21st November.
24, Srimati Sushmita.
We have filed in this case, my lord. Filing memo for dispensation of notice to R1.
Why it has to be dispensed with Amma?
Liability is accepted by the insurance company R2, my lord. Hence, it may be dispensed.
Heard Ms. Susmita G. Land Counsel for the appellant. Land Counsel files memo seeking dispensation of notice upon respondent number 1. Land Council states that as liability is admitted by respondent number 2, notice to respondent number 1 may be dispensed with. Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
To United India Insurance.
Sri Janardhan Reddy is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri Janardhan Reddy. List on 21st November.
Much obliged.
Serial number 25, Srimati Kalpana PV.
Claim petition has been dismissed, my lord. The R1 is United India Insurance Company. There's a connected matter, my lord, MFA 204 of 24, in which Geeta Raj has been asked to take notice, my lord.
Heard. Srimati Kalpana PV, Land Counsel for the appellant. Land Counsel submits that MFA 204 of 2024 is connected to the present appeal that was filed by insurance company.
No, I have only filed. There are 3 claim petitions altogether.
Is connected to the present appeal. Land Counsel states that for the United India Insurance Company Limited, Srimati Geeta Raj was asked to file wakalat.
And I have served notice on.
For United India Insurance Company Limited, and therefore the same counsel may be directed to take notice for respondent number 1 herein. Having considered the submission thus made, Srimati Geeta Raj is called upon to accept notice for respondent number 1 and file wakalat subject to entrustment of the case otherwise by respondent number 1. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Srimati Geeta Raj.
And so for a second respondent, I'll take notice.
Issue notice to respondent number 2 on furnishing the requisites. List on 25th November.
Serial number 26, Chandrana.
No representation on appellant side on call. Hence, stand over to 4/12.
27, Syed Abdul Sabur.
I am filing memo for dispensation to R1, my lord. Yes, the case of individual. The disability has taken on the lower side
So why it has to be dispensed with Mr. Counsel?
because the liability is on R2, man.
Heard Sri Syed Abdul Sabur, Land Counsel for the appellant. Land Counsel files memo seeking dispensation of notice upon respondent number 1. Land Counsel submits that as liability fee is fixed upon respondent number 2, notice to respondent number 1 may be dispensed with. Having considered the submission thus made, notice to respondent number 1 is dispensed with, however, at the risk of the appellant.
National.
Sri L. Srikanta Rao is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Appellant to serve copies of appeal papers at the chambers of Sri L. Srikanta Rao. List on 25th November.
TCR में because injury.
Call for the records from the consent tribunal in the meantime.
28, Suresh Lathur.
For appellant in this case, my lord, kindly issue notice to respondents, my lord.
Third, Miss Smita, land counsel who represents Sri Lathur Suresh Mahalingappa, land counsel on record for the appellant. Sri S.V. Hegde Mulkund is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri S.V. Hegde Mulkund. List on 25th November.
29, Jagdish PS.
Yes, Mr.
I
Counsel.
appear for the appellant, my lord, challenging the liability in this matter, my lord, on the ground that there is 4 days delay in lodging the complaint. The other point, I have examined the insurance company official, my lord, and marked exhibit R 1 to 4, stating that the non-involvement of the accident is caused due to two-wheelers, my lord, two-wheelers. But as per their narration, my lord, that the petitioner was a pedestrian, my lord. Challenging the liability on those grounds, my lord.
Heard, you are Mr. Jagdish PS.
Yes, please, my lord.
Heard,
ಹೇಳಿದೀನಿ ಮ್ಯಾಮ್ ಚೇತನ್ ಸರ್ ಫೈಲ್ ಏನೋ ಚೆಕ್ ಮಾಡ್ತಾ ಇದ್ರು.
Heard Sri Jagdish PS, land counsel for the appellant. IA 1 of 2024 is filed seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, SIRA, in MVC 516 of 2019, dated 14/3/2024. Next, land counsel Sri Jagdish PS submits that the claimant projected a false version regarding the manner in which the accident occurred, to gain wrongfully. Full stop. Though the non-involvement of the alleged offending vehicle was established before the tribunal, the tribunal fastened the liability against the petitioner appellant, and therefore an appeal is filed. Land counsel thereby seeks to stay the operation of the impugned award. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted. Thus, the operation of the order, the operation of the award that is passed by the Motor Accidents Claims Tribunal, SIRA, in MVC 516 of 2019, dated 14/3/2024, shall stand state until further orders on the petitioner appellant depositing 50% of the award amount along with accrued interest before this court within a period of 4 weeks. Next, on such deposit, the registry is directed to invest the same in any fixed interest-yielding fixed deposit scheme of any nationalized bank until further. Issue notice to respondents on furnishing the requisites. List on 25th November.
Seal number 30, pattern matter.
My lord,
Ramesh Anandan.
very long back, my lord has directed me to produce this one copy of deposition, translation copy of it is only 41,000 rupees. So it may be, if my lord released, it may be posted before the regular bench, my lord. Very long back, it is heard to some extent.
Sri Sripad V. Sastry appears through VC Sri Sripal V. Shastri and counsel for the appellant appears through VC. Full stop. Translated copies of the depositions and the documents are not yet filed. Full stop. Therefore, release the matter from the caption part heard. Full stop. Registry to list the matter before the bench having provision to deal with.
Seal number 31. Srimati Suma K.
I am for respond number 2, my lords. Number 31.
Very good. The case of death, accident is of the year 16/7/2017. Uh, 16/7/2017, he was aged 22 years.
Yes.
Your lordship, he's claiming salary of rupees
For the claimants,
are the parents, the mother and the father.
so mother only remains now.
Yes, mother only remains now.
Yes.
Lordship, in this case, they have claimed that he was working in Coorg Hawk Adventure Park. He was working as a driver and a guide. And he claims that he was getting rupees 15,000 per month. To that effect, he has examined PW3, the employer. The employer has also told that he was paying him 15,000 per month. In his evidence, he has stated because when the people come, he was taking them to tours, and also he was working in the resort and a guide and a driver. But the trial court erred in taking income
10,000 rupees.
at rupees 10,000. Lordship, my contention is that he was very young, and in the resorts, when the employer itself, they have examined the employer, and the employer has also stated in evidence that he was paying him 15,000 per month. 15,000 should have been taken. And also they have taken future prospects at 50%, Lordship, because he was in permanent employee in that company. And hence the trial court erred in taking 10,000 per month. So 15,000 should have been taken. He had a bright future, and
One submission regarding income, my lordship. They have not produced a salary certificate or bank statement, whether they have giving 15,000 rupees by check or by cash. They have not mentioned. They orally mentioned as giving 15,000 rupees. How can we believe this, my lord? Hence, maybe notional income may be taken, my lord.
What is the notional?
2017, my lordship, that
11,000.
11,000 is there, my lordship. Maybe that taken month, 11,000 maybe notional income may be taken, because there is.
Expect the counsels to be fair enough and to go through the record before making the submission. If you are accepting the submission, you need not go through the record. But if you are opposing, your opposition should be firm and based on the record. What is the crucial point involved in this case? What is the crucial point involved?
Income, my lordship.
How can you defend?
My lordship,
Portion of 15,000.
15,000 they have as orally they have given evidence, my lordship, but they have.
That point in the evidence.
But they have not produced any document to show.
That point in the evidence.
Point, my lordship.
Yes, Amma. How can you say that he is drawing 15,000 when you examine PW3 and as per your documents, the partners are getting remuneration of 10,000 per month. How can they give 15,000 to the driver?
It doesn't mean whenever a person starts a partnership firm, they will take very less, because what they want the firm to come up. Just because the partners took only 10,000, it doesn't mean that the employees are paid less.
That is a very wrong notion, in my opinion. So my contention is partners for the business to come up. They will take remuneration as less and they will see that the employees are paid very well. So when the employer is examined and the employer says that I was paying 15,000 per month, and as you know that resorts are all coming up in Bangalore, Mysore, everybody in the IT or any other people, they all want to go for weekend gateways. So getting 15,000 per month is possible for a place like Coorg, is my contention. And the trial court erred in mentioning that just because there were two partners, the partners took 10,000, they could have not inferred that the employees were getting less. That was a wrong inference drawn by the
What
trial.
about adding a 50% towards future prospects?
Your Lordship, the employer is examined. Employer says that he was
It's not a permanent job.
It's not permanent job.
It is not a permanent job. If it was a permanent job, after death, he would be getting some amount. What is that the partners are paying to him? To the legal representatives.
They have just mentioned that.
So 40% has to be taken. We are taking the income as 15,000.
National income may be taken, my lords. Because they have not produced any document to show they are paying by check or they have. Suppose in any resort, my lord, there will be statements, my lordship, through online bank statement. They have not produced any single document, they have not produced. How can we believe? In resort, there will be on ledger also. They have not produced how many they are working in resort. Orally, they have informed, given statement, they are giving 15,000 rupees. As per judgment, page number 9, my lords, kindly. Para number 13. Can I read, my lord?
Para number?
Judgment page number 8, my lordship, para number 13, my lordship.
Yes.
In order to prove the income occupation is given.
We have gone through that. We have gone through. Yes. The monthly income is taken as 15,000. We have added 40% towards future prospects, deducted 50% towards personal and living expenses, applied appropriate multiplier 18, and under conventional heads 70,000. Total comes to rupees 23,38,000.
Lordship, my contention may be taken on record, madam.
Yes,
Please, madam.
every contention will be recorded. Yes, heard. Srimati Suma K, learned counsel for the appellants, as well as Sri Mallikarjun Reddy, who represents Sri Pradeep B. Learned Counsel for respondent number 2. Dissatisfied with the amount that is awarded as compensation by the Motor Accidents Claims Tribunal, Madikeri, through orders in MVC 157 of 2017, dated 9/7/2018, comma, the claimant is before this court. Full stop. The parents of the deceased Pavan Kumar moved an application claiming compensation of rupees 37,15,000 in total. Full stop. The tribunal, through the impugned order, awarded a sum of rupees 16,90,000 as compensation. Full stop. Projecting that the said amount is unfair, projecting that the amount thus awarded is unfair, comma, this appeal is filed. Full stop. Though the parents of the deceased Pavan Kumar, within brackets hereinafter be referred to as the deceased for brevity, filed a claim petition before the tribunal, comma, in the light of the death of the father of the deceased, comma, the appeal is preferred by the mother alone. Next. Arguing the matter, Ms. Sumayan submits that the deceased was working as guide cum driver at Coorg Hawk Avenue Park Club, Koppa village of Periyapatna Taluk by the date of accident. Full stop. He was paid salary of rupees 15,000 per month, apart from beta of rupees 100 per day. Full stop. To establish the occupation and income of the deceased by the date of accident, comma, the claimants examined PW3, who is the owner of, who is the employer of the deceased. Full stop. PW3 spoke in clear terms that the deceased was working under him till the date of accident, and he was being paid salary of rupees 15,000 per month and also beta of rupees 100 per day. Full stop. But without considering the said evidence, the tribunal fixed the notional income as rupees 10,000 per month and proceeded with the calculation of proceeded with award of proceeded with the calculation and awarded a sum of rupees 16,90,000 under all heads, which is unjustifiable. Full stop. Land Council thereby seeks to do justice. Full stop. Next. The submission that is made by Sri Mallikarjun Reddy for respondent number 2, on the other hand, is that the appellant, the claimants have not produced any cogent and convincing proof with regard to the occupation and income of the deceased by the date of accident. Full stop. The evidence of PW3 cannot be taken into consideration as his evidence is not based on any material, any documentary proof. Full stop. Land Council also states that the income taken as rupees 10,000 per month notionally is highly justifiable. Full stop. Next. A perusal of record reveals that apart from evidence of PW3, the claimants have also produced attested copy of the certificate of registration of the firm, which is marked as Exhibit P13. Full stop. They have also produced they have also produced the attendance register, which is marked as Exhibit P12. Full stop. The tribunal made a clear mention that in Exhibit P12, the name of the deceased is found at serial number 9. Full stop. The tribunal, taking into consideration the contents of Exhibit P14 partnership deed, where the remuneration of the partners is mentioned as 10,000 per month, took the notional income of the deceased as rupees 10,000 per month. Full stop. The submission that is made by Land Council for the appellant in this regard is that the partners who have started the firm and intended to establish the same, were taking very less remuneration and were investing their entire earnings for the development of the firm. Full stop. When the occupation was established by examining the employer, by producing the attendance register, and the income is also established, the tribunal ought to have taken the said evidence into consideration. Full stop. This court finds justification in the submission thus made by the Land Council for the appellant. Full stop. This court does not find any grounds to discard either the oral evidence that is produced in the form of PW3 or the documentary evidence produced, that is Exhibits P12 and P13. Full stop. Therefore, basing on the said evidence, this court considers desirable to take the income of the deceased as rupees 15,000 per month by the date of accident. Next paragraph. It is not in dispute that the deceased was aged about 22 years by the date of accident. Full stop. Therefore, 40% of the earnings of the deceased are required to be added towards future prospects as per the decision of the Honorable Apex Court in Pranay Sethi's case. Full stop. Also, as the deceased died as bachelor, 50% of his earnings are required to be deducted towards the personal and living expenses which the deceased would have incurred for himself had he been alive. Full stop. The appropriate multiplier to be applied is 18. Full stop. With the set parameters, the loss of dependency, is calculated as under. Tabular form, notional, no, don't write notional, monthly income. Monthly income 15,000. Annual income 1,80,000. Add 40% towards future prospects, 2,52,000. Deduct 50% towards personal and living expenses, 1,26,000. Apply appropriate multiplier 18. On applying appropriate multiplier 18, loss of dependency 22,68,000. Thus, the appellant is entitled to rupees. Thus, the claimants are entitled to rupees 22,68,000 towards loss of dependency. Apart from the said amount, they are also entitled to rupees 15,000 towards funeral expenses, 15,000 towards loss of estate, and 40,000 towards loss of filial consortium. Thus, the amount which the claimants are entitled to is as under. Loss of dependency 22,68,000. Funeral expenses 15,000. Loss of estate 15,000. Loss of filial consortium 40,000. Total 23,38,000. Thus, this court is of the view that the appellant is entitled to a sum of rupees 23,38,000 as compensation. Thus, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Madikeri, through orders in MBC 157 of 2017, dated 9/7/2018, is enhanced from 16,90,000 to 23,38,000. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. The second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Next, on such deposit, the appellant is permitted to withdraw the entire amount.
Much obliged.
Bill number 32. Sri Harish Babu, Sri Ashokan Patil.
My lord, judgment is in Kannada. Dismissal of the case on the ground.
Learned Counsel Sri Harish Babu KN seeks time to file translated copy of the impugned order. Hence, stand over to 23rd October.
3. Sri Gowda CM, Sri A. Venkatesh for R2.
Respondent.
No representation on appellant side on call. Where is the proceedings? There was no representation on appellant side even on 9/3/2023. To give fair opportunity, list on 18th September. 18th September.
34. Suresh Yamlatur,
I'm for the appellant in this case, my lords. Kindly post it for tomorrow, my lords.
Sri K. Kishore Kumar for respondent.
Yes, Mr. Counsel.
Kindly post it for tomorrow, my lords.
Your lordship may kindly post it next week, my lord, instead of tomorrow.
Why it should be urgent? Tomorrow or next week, why it should be urgent?
I need to file some citations in this case, my lords. Henceforth.
But tomorrow, my office is having a busy schedule, my lord. So your lordship may kindly post it next week. Any day next week.
You are on record, Amma?
No, I'm representing Mr. Kishore Kumar Reddy. The same, my colleague.
With due respect, whether the court is sitting idle, you are busy with your work, whether the court is sitting idle.
No, my lord, since tomorrow, since he is seeking time tomorrow, I requested for Monday or Tuesday, that's all, my lord. I am not seeking any time today.
Your good name, Mr. Counsel.
Shri Latur.
Ketan, my lords.
Sri
Ketan Latur.
Ketan Latur, representing Sri Latur Suresh Mahalingappa, appellant, appears through VC. Full stop. Srimati Aruna, representing Sri K. Kishore Kumar Reddy, for respondent number 2, also appears through VC. Full stop. Sri Ketan Latur seeks time. Hence, stand over to 23rd October.
Much pleasure.
CL number 35. Suresh M.
I for the
Latur.
appellant in this case, my lords.
Shri Umesh.
I pray for time in this case, my lords.
Why, Mr. Counsel?
Same citations. I need to file citations in this case, my lords.
These are 2021 matters, Mr. Counsel.
Yes, my lords.
If you want
Citations.
to file citations, you should be ready with the citations.
Yes, my lords. Yes, my lords.
That is not a ground for seeking adjournment.
But it may be posted for tomorrow, my lords. I'll post it for tomorrow.
Sri Ketan Latur, representing Sri Latur Suresh Mahalingappa, appears through VC and seeks time. No representation on respondent side. Stand over to same datum.
36. Sridhar DS.
Friends Counsel, my lord. Case of injury, my lord, I am challenging the contributory negligence held by the trial court on the reason that the minor was driving the motorcycle, met with the car was dashed against the minor's bike. With the observation of the trial court that minor had no driving license, he was aged about 17 years. So it is a contributory negligence. See, my opponent has to establish that because of the driving of the vehicle by the minor in the hazardous manner or in such a way that it caused accident, alleged accident, there is no such evidence, my lord. Mere the minor rode the vehicle, that caused the negligence is not the ground for its one. Trial court's observation that minor drove the vehicle. Charge sheet filed against the car, my lord. 30% negligent contributory held. My submission is it can be removed, my lord.
Can it be reduced to 10%, Mr. Counsel?
Which one? Your lordship, kindly see the exhibit P5. Exhibit P5, that is the IME report, which indicate how the accident was made. Basing on that, my lord,
Records received, amma?
There is no.
Admit and list for final hearing, Mr. Counsel.
Pardon?
Here, we list for final hearing. Heard Sridhar DS, Land Counsel for the appellant.
Sridhar, on behalf of Sridhar KV Shampas.
I heard Sri KV.
Because he is not feeling well, that's why I am representing.
Presents Sridhar DS, Land Counsel on record for the appellant as well as Sri BC Shivanagoda, Land Counsel for respondent number 2. Admit. List the matter under the caption final hearing on 22nd October.
Meanwhile, call for the record also.
Records are available.
CL number 37. Srimati Lalita Manihar. CL number 37.
No representation on either side on call. To give fair opportunity, list on 24th September.
38. Sachin BS. Sri Balraj AC.
Seeking enhancement. Accident occurred on 16/12/2015. Offending vehicle, KSRTC, charge sheet against KSRTC.
So on what should you have preferred appeal?
And notional income is 2015 notional income 9,000, my lordship, is taken on 7,000, my lordship. And future medical expense, the doctor suggestion on 14,000, my lordship. Trial costs taken on 15,000, my lordship.
What are the nature of, what are the injuries sustained?
3 injuries, my lordship. 2 type of 11 ink page number 13, my lordship, issue number 2, my lordship. Type 11 open fractures of the right tibia and fibula, my lordship, without NV default, and right hand little finger amputation, my lordship. 2 is major, 1 is a
So the disability is taken as 14%.
14%, my lordship, overall body.
Not.
Yes, Mr. Counsel.
My lords, with regard to the income, they have not produced any document evidencing they were earning about 21, earning about 15,000 with regard to no document proof has been produced. Also, there has been no witness examined with regard to that, my lords. That is my only submission in terms of enhancement.
So the notional income is taken as 9,000. Loss of earnings, loss of future earnings due to disability comes to rupees 3,59,856. And the loss of income during laid up period is taken for 4 months, it comes to 36,000. So the total enhancement would be 1,74,936. Third, Sri Sachin BS.
On behalf of Sachin BS, Harsha Maraj.
Heard Sri Harsha, Land Counsel who represents Sri Sachin BS, Land Counsel on record for the appellant. Full stop. Also heard
Mithun.
Sri Mithun, Land Counsel who represents Sri Balraj AC, Land Counsel on record for the respondent. Next, this is a claimant's appeal. Full stop.
GG.
The order under challenge is the one that is rendered by the Motor Accidents Claims Tribunal, KGF, in MVC 35 of 2016, dated 27/11/2018. Full stop. As against the claim for rupees 15 lakhs in total, comma, the tribunal through the impugned order awarded a sum of rupees 3,74,876 as compensation and aggrieved by the same, the present appeal is filed. Next. Arguing the matter, Sri Harsha,
Yes, ma'am.
representing the appellant, submits that the appellant as a mason and mastri was earning rupees 20,000 per month by the date of accident. Full stop. However, the tribunal took the notional income of the deceased as rupees 9,000 per month and 7,000 per month and awarded a grossly low sum as compensation under the head loss of future income due to permanent physical disability. Full stop. Land Counsel also states that the tribunal did not award justifiable sum as compensation under any head, and therefore the appellant is before this court. Full stop. Learned counsel ultimately seeks for enhancement of compensation. Next paragraph. The submission that is made by Sri Mithun for respondent on the other hand is that the appellant did not produce any proof with regard to his occupation or earnings by the date of accident. Full stop. Therefore, the tribunal took the notional income of the appellant as rupees 7,000 per month. Full stop. Learned counsel also contends that the amount awarded as compensation under all heads is highly reasonable and therefore the appeal is not maintainable. Full stop. Next paragraph. A perusal of record reveals that the tribunal subjecting the evidence of PWs 1 and 2 and exhibits P5 to P13 to scrutiny came to a conclusion that the appellant is entitled to a sum of rupees 3,74,876 as compensation. The sum thus awarded is under following heads A to A. There is no denial of the fact that the appellant sustained type 2 open fracture of right tibia and fibula, and there was amputation of right little finger, full stop. Those injuries are grievous in nature. Full stop. PW2 deposed that the appellant suffers with 36% permanent disability in respect of his right lower limb and 2% in respect of his right little finger, and the permanent disability in respect of whole body is 14%. The tribunal, considering the evidence of PW2, took the permanent disability in respect of whole body as 14%. Full stop. To this court does not find any grounds to interfere with in that regard. Next. Coming to, next means next paragraph. Coming to the income and earnings of the appellant by the date of accident, comma, though the appellant contended that as mason and masonry he was earning rupees 20,000 per month, comma, as rightly submitted by Sri Mithun, learned counsel for the respondent, no evidence is produced to that effect. Full stop. The submission that is made by Sri Harsha for appellant in this regard is that the accident occurred in the year 2015 and for the relevant period, even the Karnataka State Legal Services Authority is taking the notional income as rupees 9,000 per month for settling the claims, and at least the set figure should have been considered by the tribunal. Full stop. This court finds justification in the submission thus made. Full stop. Therefore, this court considers desirable to take the notional income of the appellant as rupees 9,000 per month by the date of accident. Next paragraph. It is not in dispute that the appellant was aged about 28 years by the date of accident. Full stop. Therefore, as per the decision of the Honorable Apex Court in Pranay Sethi's case, full citation. Pranay Sethi's case, 40% of the actual earnings are required to be added towards future prospects. Full stop. Also, as per the decision of the Honorable Apex Court in Sarla Verma's case, comma, the appropriate multiplier to be applied is 17. Full stop. Thus, with the aforementioned parameters, comma, the loss of future earnings due to permanent physical disability is calculated as under tabular formula. Notional monthly income 9,000, annual income 1,08,000, add 40% towards future prospects, 1,51,200. Apply appropriate multiplier 17, 25 lakhs, 70,400. 14% being permanent physical disability, loss of future earnings, 3,59,856. Next para. The tribunal, through the impugned order, awarded a sum of rupees 1,99,920 towards loss of future earnings. Full stop. However, the amount which the appellant is entitled to towards loss of future earnings is 3,59,856. Full stop. Thus, the enhancement in this regard will be 1,59,936 within brackets 3,59,856 minus 1,99,920. Next paragraph. Having considered the nature of injuries sustained, that is type 2 open fracture of right tibia and fibula and amputation of right little finger, this court is of the view that the appellant would not have attended his normal pursuits at least for a period of 4 months. Full stop. Thus, the loss of earnings during laid up period comes to rupees 36,000 within brackets 9,000 into 4. The tribunal has awarded a sum of rupees 21,000 only towards loss of earnings during laid up period. Stop. Thus, the enhancement will be 15,000 within brackets 36,000 minus 21,000. Stop. Thus, the amount which the appellant is entitled to, in addition to the amount that is awarded by the tribunal through the impugned order, is 1,74,936 within brackets 1,59,936 plus 15,000. Stop. In the light of the foregoing discussion, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal KGF through orders in MVC 35 of 2016 dated 27/11/2018 is enhanced by 1,74,936. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. Next, the respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Next, on such deposit, the appellant is permitted to withdraw the entire.
Case number 39, Sri Maruti GB.
Claimant's appeal for enhancement, my lord. Case of the injury, matter may be referred to the Lok Adalat, my lord.
No.
At request of your Mr. Maruti.
Please, madam.
At request of Sri Maruti GP Land Counsel for the appellant, as well as Sri C. Sinkar Reddy Land Counsel for respondent number 3, the matter is referred to Lok Adalat for settlement.
Please.
CL number 40, Shri Shripad V. Shastri, Shri Pradeep B.
But I am for appellant case of injury only for enhancement, my lord. Only for enhancement.
Second respondent.
My lord, a dentist lady, my lord, met with an accident on 17/11/2017.
Yes, Mr. Counsel.
my lord, she is aged 33 years and a dental surgeon, claims to be earning 35,000 per month. My lord, she sustained crush injury to left leg, my lord. Page number 9, para number 13 onwards is relevant. And crush injury to left leg and skin loss and cut lacerated wound and fracture of toe, my lord. Right toe. My lord, I have examined total 4 witnesses. She was treated in 2 different hospitals. Bhagwan Mahavir Hospital for 5 days and Columbia Asia Hospital for 3 days. Well, PW4 is a doctor, man. PW4. Well, she underwent surgery for a fixation of steel rods and it is removed and open reduction internal fixation was done after removal of external fixator. But according to doctor, she is suffering from 21% of whole body disability. Well, medical expense 1,15,000 that has been accepted. Well, main ground for appeal is disability or future loss of earning and earning capacity is not awarded on the ground that she is earning the same amount even after accident. Well, since it is a private avocation, definitely my respectful submission is being a dentist, she is suffering now the ailment, the disability. Her earning capacity is reduced. That is suitably quantification is necessary, my lord. Loss of immunities, my lord. Only on that count, my lord, the chart, page number 16 is the column on which the compensation is awarded. Well, recently, Apex Court held in a chartered accountant case, my lord. Since it's a private avocation, definitely it will come. It will reduce the earning capacity of the chartered accountant. My lord, that has quantified. My lord, my humble request is, my lord, that is
Yes, Mr. Counsel.
Lord, in the cross-examination, the PW1 is injured, was admitted that after the accident is continuing the same job, my lord, that to husband's clinic. My lord. There is no loss of future earnings. My lord, my lordship may increase in loss of amenities.
So globally, how much can be increased?
Global, my lord, overall, my lordship may increase to 50,000.
my lord, as my state earlier stated, merely because she continued in the same profession, that does not mean that her earning capacity is reduced. She being a lady aged 33 years, a dental surgeon, her service to the society is very much necessary. Definitely, these this type of injury, there is 21% whole body disability. Definitely, it reduces the earning capacity. But even though she continued pursued the same avocation, that does not mean that she is not entitled for future loss of earning or earning capacity. It may be reduced not as equal to 21%. At least 15% may be considered as a loss of earning capacity, and it is to be capitalized by adopting the proper multiplier. That is my humble request, ma'am. Globally, granting 50,000 may be too low.
If that is so, my lord, they would have produced the income tax returns of subsequent, whether that income has been reduced.
No,
16,
I am not
17,
on that point. I am not
16,
on that
7.
point. My lord, I am not on that point. Her earning may be same, continuing the same. But my lord, to earn that amount, my lord, she is now facing difficulty and Suppose if she is not, the presumption is, suppose if she is not suffered this type of subsisting disability, my lord, definitely she may earn more. With this disability, my lord, she may continue to earn same. That is a different aspect, because in Supreme Court in Chartered Accountants case clearly held that, my lord, the earning capacity is to be compensated. A private avocation, if the injured following private avocation, well, definitely these are in that case, chartered account, he has to visit so many places. That is all come in the way of his profession. That is why I am not insisting to consider the monthly income of 35,000. At least her this physical part, physical disability, at least by considering some amount, by adopting the multiplier method.
They have not substantiated to consider the multiplier method. Madam. Here, my lord, what is the actual loss due to the accidental injuries? That would be the relevant, my lord. An oral assertion, my lord, there is no evidence laid in by the PW1 itself. The oral assertion cannot be taken into consideration to grant a multiplier, adopting multiplier method and granting future loss of earnings.
My lord, as
There
far
should
as
be
these,
substantial evidence, my lord. What is the actual loss due to the accidental injuries?
my lord, as far as this submission is concerned, my lord, the subsisting disability presupposes, and the presumption is to be raised that her earning capacity is reduced. Suppose she is a government employee and is having same salary and increasing salary, my lord, definitely I may not insist for that. But it's a private avocation, merely because, my lord, the earning is same.
Regarding that, my lord, division bench of the Honorable Court in private sector only, when the person who is continuing the same profession, there is no question of granting loss of future and does not arise. My lordship kindly pass, or my lord, I'll bring that, my lord, judgment.
My lord, in
My
a
lord, friend also knows very well that judgment.
My lord, as far as this aspect is concerned, Supreme Court clearly held in Chartered Accountant's case. My lord, in Chartered Accountant case, my lord, he is continuing same profession and same earning. But these methodology or this one is required to be adopted is, my lord, loss of earning capacity. That is physical disability presupposes that there is a loss of earning capacity. Well, since this multiplier method is only the method adopted by us just to give the justice dispensation of justice, well, there is in some cases it is to be given away, and the actual loss of earning capacity is to be taken into consideration. Suppose again, and I'm telling, my lord, suppose if he is a government servant, definitely I will not, he is not entitled for future loss of earning and earning capacity. But my lord, since he is a private avocation, she is doing a dental surgeon. My lord, definitely, my lord, by considering some lesser physical disability, and by adopting at least chapter in income, local income.
Yes,
That,
Mr. Counsel, you have already submitted all those points.
yes.
Heard. Sri Sripad V. Shastri. Who appears through video conference and represents the appellant. Also heard Sri B. Pradeep, non-counsel for respondent number 2, who appears physically before this court. The claimant is before this court seeking enhancement of compensation. The order in dispute is the one that is rendered by the Principal Motor Accidents Claims Tribunal, Bangalore, in MVC 82 of 2018, dated 28/11/2019. Good stuff. The only point involved in this appeal as submitted by Sri Sripad V. Sastry for appellant is in respect of loss of future earnings, is in respect of the compensation to be awarded under the head loss of future earnings, full stop. Learned Counsel Sri Sripad V. Shastri contends that the appellant is a dentist by profession. Full stop. She sustained grievous injuries due to the accident. Full stop. She produced the evidence of the and the said doctor who gave evidence as PW2 spoke in clear terms. The doctor who examined as PW4 spoke in clear terms that the permanent physical disability in respect of left lower limb is 18% and the right lower limb is 14% and the whole body disability is 21%. Full stop. Learned Counsel states that though such a convincing evidence is produced before the tribunal did not award any amount under the head loss of future earnings due to permanent physical disability, which is unjustifiable. Full stop. Learned Counsel thereby seeks to evaluate the evidence and pass necessary orders. Next. Sri B. Pradeep, Learned Counsel for respondent number 2, on the other hand, contends that the appellant was working as dentist by the date of accident and she continued the same profession. Full stop. The appellant who got examined herself as PW1 during the course of cross-examination admitted that she is continuing her profession even after the accident. Full stop. Thus, the tribunal is justified in dishonoring the request of the appellant to award any amount under the head loss of future earnings. Full stop. Learned Counsel states that as there is no loss of earnings due to the injuries sustained, award of any amount under the head loss of future earnings does not at all arise. Next step. It is not in dispute that the appellant sustained crush injury to her left leg and the said injury was treated with the fixation of plates and debridement. Full stop. Also, it is not in dispute that PW4 basing on the examination conducted assess the disability in respect of whole body as 21%. Full stop. Admittedly, a dentist is not required to perform is not required to conduct her duties with extensive labor work. Full stop. However, the undeniable fact would be that the dentist is required to stand and perform the required procedures to the patients. Full stop. Also, the appellant, being a woman, would be facing difficulty in every walk of life, either in attending her duties as a homemaker or in discharging her duties as a dentist. Full stop. Loss of future earnings does not only include the loss in respect of the monetary loss in respect of getting the remuneration or salary, but it also includes the excess amount which the injured would have to incur for performing her duties in an effective manner, that is in respect of transportation, taking the assistance of any other person while discharging the duties, etc. Full stop. Having considered all these aspects, this court is of the view that basing on the occupation of the appellant as dentist, the permanent physical disability is required to be taken as 5% in respect of whole body. Full stop. Next, the assessment of the tribunal regarding the earnings of the appellant as rupees 35,000 per month needs no interference. Full stop. Also, it is not in dispute that the appellant was aged about 33 years by the date of accident. Full stop. Thus, the appropriate multiplier to be applied as per the decision of the Honorable Apex Court in Sarla Verma's case, right, full citation, is 16. Full stop. Thus, the loss of future earnings due to permanent physical disability will be as under tabular form. Monthly income 35,000.
35,000, Milord, would not be correct, Milord, because Milord, 35,000, 3 months has already granted 1,05,000. 1,05,000 has already awarded, Milord.
Yes,
That
is
Milord,
loss
3
of-
months.
Yes, yes.
But loss of, whether that 35,000 they have lost and every month and
No,
all, they have not substantiated, Milord. They
No,
have
it is
filed their
only-
income tax returns in the year of 16-17.
There is no other go except to honor the findings given by the tribunal, which are
Moreover,
favorable.
my lord is considered only 5% disability.
No, Milord, loss of future earnings is concerned.
That
Milord,
is-
Milord,
You are taking the income as
they
35,000.
have not substantiated it, Milord. What is the loss due to the accidental, Milord,
No,
injuries?
no.
No, monthly income 35,000, annual income 4,20,000. On applying appropriate multiplier 16, 67,20,000. Permanent physical disability being 5%, loss of future earnings 3,36,000. Full stop. Thus, the appellant is entitled to a sum of rupees 3,36,000 towards loss of future earnings on account of permanent physical disability. Full stop. This court does not find any other grounds to interfere with the findings given by the tribunal. Full stop. Thus, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Principal Motor Accidents Claims Tribunal, Bangalore, through orders in MVC 82 of 2018, dated 28/11/2019, is enhanced by 3,36,000. The enhanced amount shall carry into the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. The second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Instead of on such deposit, the appellant is permitted to withdraw the entire amount.
41. Seal number 41, Shri Harish Babu. Shri Pradeep B.
Hearing for the second
Points
response.
appeal. For enhancement, the only ground here, the petitioner has sustained, the claimant has sustained fact, contusion over right temporal region, scalpel, contusion right parietal lobe, and he has been admitted for 21 days in the hospital. He has undergone surgery. He has admitted in 2 hospitals. He has undergone surgery. So pain and suffering, they have given only 10,000. My prayer to be enhanced by another 20,000. Conveyance and nourishment, attendance charges, everything they have given only 21,000. According my contention is 15,000 for each, totally 45,000. Medical expenses, they have produced medical bill amounting to rupees
For
4
pain and
lakhs.
suffering, 40,000 was given, Mr. Counsel.
Please, another 20,000 I am asking. Food nourishment, attendance, conveyance. They have given only 21,000, that to 22 days admitted. My contention is 15,000 for each, totally 45,000 it will come. 15,000 each. 45,000, you fit the food and nourishment 15,000, conveyance on 15,000, attendance totally 45,000. Medical expenses, 4,31,526.27 paisa.
Who is
Medical bills has been. PW2 is the hospital authority who has produced the documents, hospital documents. So medical bills, totally 4,31,526 rupees produced. But tribunal has granted only 2 lakhs on the ground that there is no, they have not paid the GST. GST and CST. And the income, tribunal has considered only 8,000 as income. He is a coolie. As per the chart, it has to be 12,500. Only 8,000 has been taken. Other things I am not visible. Narana.
My report has come. Yes, ma'am. PW2 evidence.
They have produced only documents. Case sheet, record technician, is a record technician of Ambika Hospital. He has produced only case sheet.
Yes, Mr. Counsel.
Lord, internal page 14 of the judgment, my lord.
14, yes.
14. Lord, during the course of cross-examination, PW1 admitted that, my lord, he has not produced the receipt of for payment of inpatient bill amount.
Yes, yes, those we are not going to interfere.
Moreover, my lord, from the bottom second line, my lord, same page. Even though PW1 has admitted in this class that I will examine the author of the exhibit P10, but later on he has not examined him to substantiate and prove that, my lord, regarding medical bills, they have not examined anybody. Therefore, the tribunal has rightly justified granting compensation under their medical expenses.
2 lakhs is granted towards medical expenses.
Please.
Income during the treatment period. You were there in hospital for
21 days.
21 days.
21 days.
On the ground that bills, there was no GST and CST mentioned in them.
Mr. Counsel, loss of amenities, 1 lakh is granted.
I am not disputing that one.
Then you will not dispute where excess amount is granted and you.
I am disputing medical bill totally 2.5 lakhs they have come down.
Any grounds to interfere.
They have 4,35,000 medical bills has been produced. Only 2 lakhs has been given.
How can you have not submitted any documents supporting to that, and those bills are not also tallying with the other relevant documents?
No, it's not, it's telling their contention is only GST and CST. The dispute is regarding only GST and CST.
Exhibit P9 prescriptions are not properly tallying with Exhibit P10 medical bills.
Only something, some madam.
No, Mr.
That too, main bill itself is 3 lakhs, so 3 lakh 16,000 main bill.
Heard. Sir, Mr. Harish Babu.
Please.
Heard Sri Harish Babu KN and counsel for the appellant, as well as Sri Bree Pradeep and counsel for respondent number 2. Dissatisfied with the amount that is awarded as compensation by the Motor Accidents Claims Tribunal, Bangalore, through orders in MEC 5710 of 2018, dated 3/1/2020, the claimant is before this court by way of appeal. The tribunal, through the impugned order, awarded a sum of rupees 3,85,000 divided under following heads. Arguing the matter, Sri Harish Babu KN for appellant submits that the appellant sustained multiple injuries in the accident and took extensive treatment. The appellant incurred a sum of rupees 4,30,000 for the treatment. However, the tribunal awarded a sum of rupees 2 lakhs only under the head medical expenses, which is unjustifiable. And counsel also states that the compensation awarded under all other heads except loss of amenities is also low, and therefore the appellant is before this court. Contradicting the submission thus made, Sri B. Pradeep for respondent number 2 contends that the tribunal, taking into consideration all the facts and circumstances of the case, awarded a justifiable sum as compensation, and therefore the award of the tribunal needs no interference. And counsel also submits that though the appellant did not choose to establish the genuineness of the medical bills, yet the tribunal awarded a huge sum of rupees 2 lakhs towards medical expenses. Next, a perusal of record reveals justification in the submission made by Sri Pradeep B. The tribunal clearly observed at para 13 of the impugned order that Exhibit P9 prescriptions are not properly tallying with Exhibit P10 medical bills. Also, the appellant did not choose to examine the doctor who treated him. Having considered the fact that the appellant sustained 1 grievous injury and 2 simple injuries, the tribunal awarded a sum of rupees 3,85,000 in total as compensation. The amount thus awarded is highly justifiable. This court does not find any grounds to interfere with the well-reasoned order of the tribunal. Therefore, this court is of the view that the appeal is not maintained. Resultantly, the appeal stands dismissed without case.
Serial number 42, Sri Manjunath ND, Sri Pradeep B, Sri Maheshwara for R1.
No representation on appellant side on call. Where is the proceeding? Please. No representation on appellant side on call. Sri Pradeep B, Land Counsel for respondent number 1 is present. Full stop. To give fair opportunity for the appellant to make his submissions list on 15th October.
43. Shri Jagdish HT.
For the appellant in this case, case of injury malad seeking enhancement of compensation, but call for TCR malad marala,
Yes, Sri Jagdish.
amputation of left leg malad.
Heard Sri Jagdish HT Land Counsel for the appellant. No representation on respondent side on call. Admit, call for the records from the consent tribunal, list the matter under the caption final hearing on 22nd October.
Please.
44. Shri Pawan Kumar, Shri JS Marulayan.
Appellant, my lord. Case of injury, my lord, challenging quantum of compensation under all the heads, my lord. The accident is in the year 2019, my lord. Yes. Yes, sustained fracture of comminuted fracture of right tibia and fibula and right humerus, my lord. The trial court has awarded 7,70,000 compensation. My lord, in the all the heads, the trial court had awarded meager compensation. My lord. The doctor has assessed whole body disability of 22%. A trial court has taken only 15%, my lord. And income has taken 10,000. In the findings, my lord, the medical expenditure was awarded 4,63,000. While calculating the same, tribunal has taken only 4,36,000 by oversight, my lord. Doctor has stated 60,000 for removal of implants. Trial court has taken only, granted only 10,000, my lord.
What was his occupation?
Driver, my lord. On 15 days he was in inpatient, my lord.
He produced his driving license, huh?
No, my lord.
Then how can you say he is a driver?
They are not disputed the occupation, my lord.
Hmm?
Insurance company has not disputed the occupation.
Denied.
So the tribunal has given a clear finding that you have not produced any documents to prove his avocational income.
Yes, my lord.
Despite of that finding, have you produced your driving license as additional evidence?
No,
Then
notional income has to be taken. The year 2019 accident.
Yes, Mr. Counsel.
Notional income to be considered and past the other rates are just and reasonable.
So we have awarded 40,000 under the head pain and suffering, food nourishment, conveyance and attendance charges 15,000.
Yes, ma'am.
Medical expenses 4,63,000. And the loss of
3,63,000.
4 lakh.
Medic.
4,63,000.
4,63,000.
Yes, in his medical expenses, 3,36,000 issue.
No, Mr. Counsel, 4,60,000.
Yes. In appeal, he has shown 3,36,000 in appeal.
It is 4,63,000. And the loss of income during laid up period 42,000, loss of future earnings 5,29,200. Yes, heard.
And future medication, madam. There are 2 fractures.
What future medication is required?
Doctor stated 60,000, but 10,000 has been awarded.
So the appeal was disposed of in the year 2019. Now we are in 2024. What future medical expenses you incurred till now?
He's not removed the
Heard.
implants.
You are Mr. Pawan Kumar?
Yes, ma'am.
Heard. Sri Pawan Kumar YN learned counsel for the appellant, as well as Sri G.S. Marulaya learned counsel for respondent number 2. The claimant is before this court seeking enhancement of compensation. Full stop. He disputes the findings given by the Motor Accidents Claims Tribunal Bangalore in MBC 4092 of 2019, dated 27/10/2021. Full stop. The tribunal, through the impugned order, awarded a sum of rupees 7,76,000 as compensation, divided under following heads. My ATM. Arguing the matter, Sri Pawan Kumar YN per appellant submits that the appellant sustained grievous injuries due to the accident and became permanently and permanently disabled. Full stop. Learned counsel states that the appellant, through the evidence of PW2, established that the permanent disability in respect of right upper limb is 46% and in respect of right lower limb is 40% and the whole body disability is 22%. Full stop. However, the tribunal took the disability in respect of whole body as 15%, which is unjustifiable. Let's stop. Next page. Learned Counsel also contends that the appellant as driver was earning rupees 20,000 per month by the date of accident, but the tribunal took the notional income of the deceased as rupees 10,000 per month, which is improper. Full stop. Next paragraph. The submission that is made by before that you write, you remove that submission that is made. Learned Counsel Sri Pawan Kumar Vayan also contends that the accident occurred in the year 2019 and for the relevant period, even the Karnataka State Legal Services Authority is taking the notional income as rupees 14,000 per month, and at least the set figure should have been considered by the tribunal. Next paragraph. The contention of Sri G.S. Marulaya for respondent number 2, on the other hand, is that the amount that is awarded as compensation under all heads is justifiable. Full stop. However, the submission that is made by the learned counsel for the appellant regarding the notional income to be taken as 14,000 per month may be considered. Full stop. Next paragraph. It is not in dispute that the appellant sustained fracture of left tibia and fibula and fracture of right humerus. Fracture of right tibia and fibula. The appellant sustained fracture of right tibia and fibula and fracture of right humerus, which are grievous in nature. Full stop. As rightly contended, PW2 assess the disability in respect of whole body as 22%. Full stop. However, this court does not find any grounds to interfere with the findings given by the tribunal that for assessment of compensation under the head loss of future earnings, the disability in respect of whole body is to be taken as 15%. Full stop. Also, this court considers desirable to take the notional income as rupees 14,000 per month as prayed for. Full stop. Admittedly, the appellant was aged about 37 years by the date of accident. Full stop. Thus, 40% of the actual earnings are required to be added towards future prospects as per the decision of the Honorable Apex Court in Pranay Sethi's case. Full stop. The appropriate multiplier to be applied is 15 as per the decision of the Honorable Supreme Court of India in Sarla Verma's case. Full stop. Thus, loss of future earnings due to permanent physical disability if calculated will be as under. No tabular form. Notional monthly income 14,000. Annual income 1,68,000. Add 40% towards future prospects 2,35,200. Apply appropriate multiplier 15. 35,28,000. Loss of future earnings. Permanent physical disability being 15%. 5,29,200.
Lordship, whole body disability is 22%. There are two
Mr.
fracture, upper limb and
Next. Coming to the medical expenses, the tribunal through the impugned order granted a sum of rupees 4,36,000 towards medical expenses. Full stop. However, the tribunal at para 18 of the impugned order, discussed about the medical expenses that are required to be awarded and came to a conclusion that the medical expenses comes to rupees 4,63,000. Full stop. Therefore, the medical expenses to be awarded is, therefore, the compensation to be awarded under the head medical expenses is 4,63,000. Full stop. Also, having considered the nature of injuries sustained, this court is of the view that the appellant is entitled to a sum of rupees 40,000 under the head pain and suffering. Full stop. Also, a sum of rupees 15,000 is required to be granted under the head food, nourishment, conveyance and attendant charges. Full stop. The next para. The appellant admittedly sustained 2 grievous injuries and took treatment as inpatient. Full stop. Therefore, this court is of the view that the appellant would not have attended his normal pursuits at least for a period of 4 months. Full stop. At least for a period of 3 months. 3 months. Full stop. Thus, the loss of earnings during laid-up period comes to rupees 42,000. Within brackets 14,000 into 3. Full stop. Thus, the compensation which the appellant is entitled to is as under tabular form. Compensation for pain and suffering 40,000. Food, nourishment, conveyance and attendant charges 15,000. Medical expenses 4,63,000. Loss of income during laid-up period 42,000. Loss of future earnings due to permanent physical disability 5,29,200. Loss of amenities in life 20,000. Future medical expenses 10,000. Add it and full stop. In the light of the foregoing discussion, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal Bangalore through orders in MVC 4092 of 2019 dated 27/10/2021 is enhanced from 7,76,000 to so and so. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. The second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Next, on such deposit, the appellant is permitted to withdraw the entire.
Seal number 45. To Syed Abdul Sabur.
45, please,
Reddy.
Lord. In second case, I am appearing. 45/1.
45/1.
No DL pain required to be ordered.
No DL, huh?
No DL.
DL is no effective valid license.
The finding from the para 26, 27.
Recovery was ordered.
Please.
But
What ground you are disputing the
enhancement, my lord, there is a.
thing for enhancement?
Lord, first take my case, please, madam. It runs to 28/55/22. The discussion begins from prior 18, please.
Both appeals are filed by the.
Connected and.
It is common judgment, my lord, arising out of same accident.
You have not filed any appeal.
I have not filed any appeals.
Yes.
My lord, I'm drawing the attention to para 5, my lord. The appellant fell down and sustained right knee injury, my lord. And he has taken to Government Hospital, Bannur, and took treatment, and then Shakti Hills Hospital, Mysore, wherein he is inpatient, my lord. He underwent surgery, right knee.
Those are the pleadings, Mr. Counsel. What is the evidence?
Yes, my lord. He has produced the own certificate, my lord, and through doctor also, my doctor, Dr. Yati Raju, he has as PW3 has examined, my lord.
Now, please come to the para 21 of the judgment, please.
Mr. Counsel, why you sought for dispensation of notice against other respondents? When there is an order of pay and recovery?
I'll not press, my lord.
Yes, notice has to go.
Yes,
We'll order notice. Sri Syed Abdul Sabur, if the amount is enhanced, ultimately it is the owner who would suffer. Lord Sri Syed Sabur, Land Counsel for the appellants in both the appeals. Full stop. Land Counsel submits that he filed both the appeals seeking enhancement of compensation. Full stop. Also, it is submitted that Sri Ravish Benny.
then unrepresented it is.
ಸರ್ವ್ ಆಗಿದೆ.
Okay. Then it is okay. Already served, Mr.
Served, first respondent, sir, second respondent also served, please.
Pawan,
No.
in both the cases, it is served and unrepresented.
Yes, Mr.
For my case is concerned, please, finding at 21 of the judgment, please.
Let us hear Mr. Sabur.
Your 2855.
2855.
Right knee operation has been done and doctor has been examined, my lord. As PW3, Dr. Yatiraju T. My lord, he has sustained injury of medial collateral ligament injury to right knee, man.
No.
We have produced P13 as a one certificate, man.
Certificate.
Yeah, one certificate.
Have not
P3.
established disability.
No, not permanent disability, but at least pain and suffering and other heads to be, because the tribunal has taken only 40,000 as globally. And 15,000 is medical expenses itself. When he underwent surgery, at least pain and suffering, loss of later period and all other.
Yes.
Some global compensation may grant.
Yes.
In my
Yes.
case.
What about the next case, 1128?
Is the same thing, my lord. But here the medical expenses is 92 lakhs 668, my lord. Here the medical expenses is more. And the same global expenses globally has been awarded 1,50,000. Without considering pain, suffering and other things. And income is 11,000 to be taken, the tribunal consider only 7,000 as. Since the appellant underwent surgery, some kind of disability is there, my lord.
The claim against respondent number 3 is dismissed.
Dismissed because of.
No DL
No,
as in the data. The finding is, please, my lord. It is at para 26,
No valid.
27, 28, 29 and 30. We have led our evidence and produced the 9 documents. Therefore, there is no, we have proved there is no DL as in the date of action for the driver of the offending vehicle. It is dismissed there. Now pay and recovery
Valid
to be
and
ordered.
effective driving license at the time of accident, and the same was informed by the owner of the vehicle in question.
So we have to order pay and recovery.
Pay and recovery, please.
Yes. Yes, any citations in this record? No DL?
Yesterday also, your lordship has passed the,
We have passed the orders, but.
on the
that's
same
not
ground.
Your side. We cannot,
On the same grounds.
How can it be, Mr. Counsel? Basing on the decisions you rely upon, we pass orders. Third, Sri Syed Abdul Sabur, learned counsel for the appellant in both the appeals. To hear on respondent side, list on 12th September under the caption part heard. Produce the decisions.
Serial number 46. Shri Shantraju K. Shri Pavamana Devi. Serial number 46.
No representation on appellant side on call. On 22/2024, the following order was passed. Full stop. Despite such an order, comma, no proof is produced of having paid the amount as ordered. Full stop. Therefore, IA 1 of 2022, which is filed for grant of stay of the impugned order, stands dismissed. List on 23rd October.
Forty-seven. Shri Prasanna Shetty.
Hearing for appellant, please.
Shankar Reddy for R2.
Yes,
Ready, my lords.
where is the other counsel? Will admit and list for final hearing.
Then refer it to local Adalat.
Your good name, Mr. Counsel?
SM Anfal.
Sri S.M. Anfal, representing Sri K. Prasanna Setti, learned counsel for the appellant, seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
48. Shri Prasanna Shetty.
Appearing for appellant, my lords.
Govindarajan.
Yes,
Yes, my lords. Yes, injury case, my lords.
yes.
Simple enhancement, my lords. The ground is, my lords, disability is not taken. At page number 11 of the judgment, my lords.
What are the nature of injuries?
Nature of injuries, my lords, at page number 9 of the judgment. Multiple abrasions over back of right hand, pain and tenderness over right wrist joint, right side black eye, laceration with muscle deep over lower lip on right side, fracture of right orbital roof and CSF. Yes, my lords.
What are the nature of injuries?
Fracture of right orbital roof, my lords. At page number 9, my lords, pain and sufferings para.
Multiple abrasions over back of right hand.
Right hand.
Pain and tenderness over right
right
wrist. Right side back, laceration. Lower lip. Fracture of right orbital
Roof
roof and CSF rhinorrhea. He was treated conservatively.
Yes.
He was in hospital for 3 days.
3 days. He was again admitted on 26/5/2018 with history of pain in abdomen, and it was diagnosed as cholangitis.
It has nothing to do with the accidental injury.
9 days inpatient, my lords, totally. Doctor has assessed
50,000 is awarded towards
pain and
pain and
suffering, my lord.
suffering. Yes. 51,600 towards medical expenses.
Loss of amenities 20,000 is given, my lords. Doctor has assessed disability to 13.55% in domain of mental speed attention. And it was stated to whole body, my lords.
Yes, Mr. Counsel.
Lordship, the second admission is nothing to do with the accidental injury. It is, what I could make out is that it's a bacterial infection. It has nothing to do with the injury. Regarding the disability, the tribunal finds that there is no permanent disability on which compensation can be awarded. In this regard, the evidence of the doctor may be looked into. Doctor says that the disability of the petitioner was assessed by a neurological department based on NIMAM's neurophysiological battery of Dr. Rao, and have issued disability certificate based on the said report. It is not his own assumption that this is the disability. Therefore, the tribunal has rightly held that there is no disability and consequential loss of earning capacity. Therefore, no award is given on that head. However, my submission would be the loss of amenities may be increased a little.
So globally, we intend to increase by 50,000.
No, my lords, but disability, my lords, doctor evidence, my lords.
Mr. Counsel, we are not convinced with that evidence, but no amount is awarded towards conveyance.
Yes, your lord.
No,
Under those heads.
no, my lords, kindly read, doctor has clearly stated that, my lords, the said disability will continue in future also. In focusing and concentrating, it will hamper his carpentry work. In cross-examination, my lords, no suggestion has been put.
Where is the evidence to show that he is a carpenter by profession?
My lords, avocation proof is not given, my lords.
Yes.
Yes,
Heard.
in that case, my lords, notional income has to be taken.
Heard, your Mr. Info.
SM Anfal, my lords.
Heard, Sri SM Anfal, Land Council who represents Sri K. Prasanna Setti, Land Council on record for the appellant. Also heard Sri R. Govindarajan, Land Council for respondent number 2 insurance company. Good stuff. On the ground that he sustained grievous injuries in the accident and became permanently disabled, the appellant filed a petition claiming compensation, full stop. The tribunal which dealt with the matter, that is the Motor Accidents Claims Tribunal Udupi, through orders in MVC 586 of 2016, 586 of 2018. Awarded a sum of rupees 1,31,600 as compensation. Full stop. Dissatisfied with the same, the claimant is before this court. Next, arguing the matter, Sri S.N. Infal,
Yes. SM Anfal.
SM Anfal, Land Council for the appellant contends that the appellant sustained grievous injuries due to the accident and became disabled. Full stop. Though the appellant, through the evidence of PW through the evidence of CW1 has established the nature of disability, the tribunal awarded a meager sum as compensation under all heads, which is unjustifiable. Full stop. And counsel thereby seeks for enhancement of compensation. Full stop. The submission that is made by Sri R. Govindarajan, Land Counsel for respondent number 2, on the other hand, is that the appellant took treatment as inpatient only for a period of 3 days. Full stop. He was treated with conservative management. Full stop. The evidence of CW1 is not convincing, and the same was observed by the tribunal. Full stop. Therefore, the tribunal rightly assessed and awarded a justifiable sum as compensation, and therefore the award of the tribunal needs no interference. Full stop. Next paragraph. The tribunal, through the impugned order, awarded a sum of rupees 1,31,600 as compensation, divided under following heads.
My lords, my submission is, my lords, 13.55% is stated to whole body, my lords. At least 1/3 to be taken, my lords, if not that much.
No, Mr. Counsel. What did you write? Divided under following heads. Full stop. It is not in dispute that the appellant sustained fracture of right orbital root, which was treated conservatively. Conservatively for a period of 3 days by keeping the appellant as inpatient. Full stop. Though the appellant raised a contention that he was readmitted and was treated, as rightly observed by the tribunal, the problem for which he was readmitted, that is cholangitis, does not relate to the injuries sustained, and there is no evidence that due to the injuries sustained, such a problem arose. Full stop. Likewise, the evidence of CW1 does not inspire confidence that the appellant suffers with any permanent physical disability. Full stop. Also, the appellant failed to produce any evidence with regard to his occupation and earnings by the date of accident. Full stop. Having considered all these aspects, the tribunal awarded a sum of rupees 1,31,600 as compensation. Full stop. However, the tribunal failed to award any amount towards the expenditure which the appellant would have incurred for transportation.
No, you're,
external.
sorry to interfere, Lordship. It is there in paragraph 7,000 is awarded. It is joined along with the medical expenses. Your Lordship might say the petitioner might have used the vehicle for conveyance purpose and have spent some money. Therefore, on considering all these aspects, this tribunal finds that it is just and proper to award rupees 7,000. Medical expenses is 44,000 and 7,000.
Towards extra nourishment, diet, and attendant charges separately. Full stop. Also, having regard to the nature of injury sustained, the appellant would have taken bed rest at least for a period of 1 month. Full stop. The tribunal did not award any amount towards loss of earnings during later period.
Yes, sir.
Full stop. Therefore, this court is of the view that the appellant is entitled to a global sum of rupees 50,000 50,000. Full stop. Such an enhancement, in the opinion of this court, is justifiable, having regard to the nature of injury sustained and the treatment taken. Full stop. Thus, the appeal is disposed of with the following ground. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Kumbasura, through orders in MVC 586 of 2018, dated 15/11/2021, is enhanced by 50,000. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. Second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. On such deposit, the appellant is permitted to withdraw the entire amount. Yes. Yes, yeah.
Malad, may I make one humble request, Malad?
Yes.
Serial number 53, the response counsel RJ Jayaprakash actually ought to have filed a fresh wakalat because there is a sign is not forthcoming. He requested me, he is not keeping well. That is why requested me. He already secured the wakalat, fresh wakalat. That is why next week at any date.
Sri Shripad V. Shastri, then counsel for the appellants, appears through VC and submits that Sri R. J. Prakash is not keeping well, and therefore time may be granted for him to file wakalat for R2. Full stop. In the light of the submission thus made, stand over to 23rd October.
My lord, can I make one submission, my lord? Serial number 69, my lord. I just wanted a short date, my lord. I will not take more than 15 minutes in this case. Only negligence is challenged.
59.
69, my lord. 69, my lord.
This is 2022 matter, Amma.
My lord, I'm unwell for the past 2 days, my lord. I'll come next week, my lord.
Srimati Renuka HR, Land Counsel for the appellant, appears through VC and seeks time. Hence, stand over to 27th September.
57, my lord.
Like,
57 serial.
57.
my lord, can it be on 26/9, my lord, if I'm 1 day?
26/9.
Yes.
26/9. Yes.
57 serial number.
57.
I informed other side also. Morning I saw it.
You are Mr. Teja Sen.
Rohan.
Rohan. Sri Rohan, representing Sri Teja Sen, Land Counsel on record for the appellants, seeks time. Hence, stand over to 15th October.
Serial number 70, my lord. I am on behalf of Krishna Kumar. I am representing Krishna Kishore. Press week's time, my lord. His inconvenience maybe matter may be posted next week, my lord.
Sri Mallikarjun Reddy, representing Sri Krishna Kishore, yes, Land Counsel on record for respondent number 1, seeks time. Hence, list on 30th September. 30.
Serial number 51, my lord. I'm here for the respondent, my lord. Another 9 connected matter is, my lord. It may be tag along with it. 1, my lord.
1. 51.
Please,
Yes.
Another 5 connected matters is there, my lord.
Have you informed the other side?
Please, my lord, already. They are filed. Insurance company has filed the
You are representing whom?
P. Natraj, my lord.
Huh?
P. Natraj. Respondent, my lord. Respondent number R1, my lord.
Your good name, Mr. Counsel.
Lokesh, my lord.
Sri Lokesh, representing Sri B. Natraju, Land Counsel on record for respondents 1 and 2. In MFA 5135 of 2022, submits that how many matters are there?
9 matters, ma'am.
MFA so-and-so are connected to the present set of appeals. Full stop. In the light of the submission thus made, registry to verify and to list these appeals along with MFA so-and-so on 22nd October.
Please, ma'am.
Lordship, serial number 63 and 64, my lordship. I representing Kavita HC. Lordship, the counsel on record already informed the other side, my lordship. any date?
These are 2021 matters, Mr. Counsel. Why? Let us see.
Counsel on record on Atlin station,
Let us see when the matter is.
please.
This side on call. Hence, stand over to 30th October, 30.
For appellant, my lord. In case of injury, the amputation of right leg below knee. Disability is considered by the tribunal is 50%. And the income taken by the tribunal is 12,000 instead of 14,000 as per the chart. And
Yes.
future prospectus is not considered. And the compensation and all the aids, including pain and suffering and amenities and attendance charges are on lower side, my lord. And is working as a head cook and running a catering. But to substantiate that contention, no documents has been furnished apart from
The national income can be taken at 14,000. 10% future prospects, it becomes 15,400. 50% disability compensation will come to 8,31,600.
the future person has to be considered.
No, that's added. Even if it is added, it comes to 8,31,600 as against 6,48,000 rupees awarded by the tribunal. So the enhancement under that head will be 1,83,600.
$15,400. How much it comes? 8,31,000.
8,31,600.
Compensation, pain and suffering is concerned, only 50,000 is awarded, my lord. That is.
So
required.
age is 55 years.
Yes, my lord.
Yeah, 55 years. Yes.
Function disability is taken 50%.
Multiplier is 11.
Multiplier is 9, your lordship.
57 years, my lord. Sorry. It is accident, no, age is 55 years, but instead of 11, they have taken the multiplier is 9, my lord.
57 years.
Is 57 years.
In the para 18, case sheet, the age of petitioner, the date of accident is 55 years. Petitioner has not produced document to show before the accident he was, as per the case sheet, the age of the injured is 55 years, my lord. It is observed.
And the tribunal took it as 57 years. Record received, Amma? No, ma'am.
Your entire record with me, my lord.
No. So we have to go through the record. What do you say, Mr. Counsel, whether it is 55 or 50?
So as per the records supplied to me by the insurance company, it is 57 years, no other documents. Sir.
Case sheet.
No, we have to call for the records then.
Maybe taken as
Because
57 years and because
57, it may be taken.
Multiplier may be taken as 9 and it may be recalculated.
But there is no reasoning is forthcoming, my lordship. Why age of
That's what para 18 it is mentioned as 55 years. And para 19 it took as 57 years. What is the right age? We do not know.
As per the case sheet, I have produced the documents, my lord.
We have to get the record. Which court this is?
Age of
Assam.
petitioner as from the date of it.
In the cast title. Sorry, my cast title it is stated as 57. that's
57
why.
years.
We'll take it as 57.
In the cost title, it is taken as 57. I was also trying to find out on
Multiplier is 9.
9 years. So 15,400 into 12 into 9
Let us see.
and 50% thereof.
Amenities also is on lower side, my lordship.
Let
Income,
us see, let us see. So we have taken the notional income as 14,000.
Plus 10% as a future prospect, it will be
Prospects,
15,400,
50% being the disability.
50% disability,
Yes, it comes to 8,31,600.
600.
Yes.
So the enhancement will be 1,83,000.
Mr. Counsel, for
Yeah.
pain and suffering, we have enhanced the amount from 50,000 to 1 lakh. Attendant charges nourishment 5,000 to 20,000. Loss of earnings during laid-up period 50,000 to 1,40,000.
1,40,000.
Yes,
This
for
how many?
10 months. 14,000 at the rate for 10 months.
3 to 6 months will be reasonable, your lordship.
Mr. Counsel, see, amputation.
No, I fully agree. That's why I didn't.
Amputation of limb, how much training he required for at
No.
least walking?
But at a period of maximum 6 months may be granted, your lordship.
See, it should be reasonable. Third. Sri Girish B. You are Mr. Girish B. Baldari.
Yes,
Third,
ma'am.
Sri Girish B. Baldari, learned counsel for the appellant, as well as Sri Govindaraj N, learned counsel for respondent number 1.
Govindarajan R, not N.
Govindarajan R,
R.
learned counsel for respondent number 1. Dissatisfied with the amount that is awarded as compensation, the claimant is before this court challenging the order that is rendered by the Motor Accidents Claims Tribunal, Hassan, in MVC 609 of 2020, dated 8/12/2022. Full stop. As against the claim for rupees 40 lakhs in total, the tribunal through the impugned order awarded a sum of rupees 11,10,709 as compensation. Next pair. Sri Girish P. Baldari, arguing the matter, representing the appellant, contends that the appellant, as a caterer and head cook, was earning rupees 25,000 per month by the date of accident. Full stop. The appellant, due to the accident, due to the injury sustained in the accident, lost his lower limb below knee. Full stop. Therefore, the appellant became totally disabled to work. Full stop. Though sufficient evidence was produced before the tribunal in respect of all the aspects of the case, the tribunal awarded a meager sum as compensation, and therefore the appellant is before this court. Full stop. Learned Counsel also contends that the tribunal took the notional income as rupees 12,000 per month only. Full stop. Learned Counsel contends that the accident occurred in the year 2019, and for the relevant period, the Karnataka State Legal Services Authority is taking the notional income as rupees 14,000 per month, and at least the said figure should have been considered by the tribunal. Full stop. Learned Counsel thereby seeks for enhancement of compensation. Full stop. Sri Govindarajan N.
R.
R.
Initially, sir.
Learned Counsel for respondent number 1, those states that the compensation awarded by the tribunal is justifiable, however, did not raise any objection to reassess the computation of compensation, taking the notional income as rupees 14,000 per month as sought for by Learned Counsel for the appellant. Next, also, the request made appears justifiable. Full stop. Therefore, the notional income of the appellant is taken as rupees 14,000 per month by the date of accident. Next. Next paragraph. It is not in dispute that the appellant was aged about 57 years by the date of accident. Full stop. Thus, 10% of the actual earnings are required to be added towards future prospects as per the decision of the Honorable Apex Court in Pranay Sethi's case. Full stop. Likewise, the appropriate multiplier to be applied is 9. Full stop. Thus, the compensation which the appellant is entitled to under the head loss of future earnings due to permanent physical disability being 50% as assessed by CW1 is as under. Notional monthly income 14,000, annual income 1,68,000, add 10% towards future prospects 1,84,800, apply appropriate multiplier 9, 16,63,200, loss of future earnings, the permanent physical disability being 50%, 8,31,600. The tribunal, through the impugned order, assessed and awarded compensation of rupees 1,10,709 under following heads. A to B. There is no denial of the fact that the appellant sustained
BW1. Yes.
crush injury to right foot coupled with vascular injury. Full stop. It is also brought on record that there was a right leg below knee amputation as the said leg lost its functioning due to stoppage of blood flow. Full stop. It is also brought on record that the appellant took extensive treatment for the said injury. Full stop. Having considered the fact that there was amputation of the lower limb below knee, this court is of the view that the appellant would not have been in a position to attend his normal pursuits at least for a period of 10 months. Full stop. Therefore, the loss of earnings during laid up period comes to rupees 1,40,000. Full stop. However, the tribunal awarded a sum of rupees 50,000 only under the said head. Full stop. Also, this court is of the view that the appellant is entitled to a sum of rupees 1 lakh under the head pain and suffering and rupees 20,000 towards attendant, nourishment, food and conveyance charges. Full stop. Thus, the total compensation which the appellant is entitled to under different heads is as under. Compensation for pain and suffering, 1 lakh. Medical expenses, 3,07,709. Towards attendant, extra nourishment, diet and conveyance charges, 20,000. Loss of amenities in life, 50,000. Loss of earnings during laid up period, 1,40,000. Loss of future earnings, 8,31,600. Add it up. Thus, in the light of the foregoing discussion, this court is of the view that the appellant is entitled to a sum of rupees so and so. Full stop. Thus, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is granted by the Motor Accidents Claims Tribunal Hassan through orders in MVC 609 of 2020, dated 8/12/2022, is enhanced from 11,10,709 to so and so amount. Full stop. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. Respondent number 1 is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. On such deposit, the appellant is permitted to withdraw the entire.
I was just checking up whether there is any delay.
Delay ಇದೆ ಎಷ್ಟಿದೆ?
No delay.
Delay ಇದೆ. Address ಮಾಡಿದೆ, delay ಇಲ್ಲ. February 2023.
In time.
In time.
Much obliged.
56. Sushmita. Shri Pradeep B.
I'm for respondent working on that.
No representation on appellant side on call. Sri Mallikarjun Reddy representing Sri B. Pradeep for respondent number 2 is present before this court physically. To give fair opportunity, stand over to 6th November.
6 minutes. Much obliged.
57 to 59 urgent, 60. Jagdish HT, Sri O Mahesh.
No representation on either side on call. To give fair opportunity, list on 6th November.
61. Sri Loikem, Sri D. Vijay Kumar.
Respondent in this case, please. A case of injury, madam. It's case of injury. Lord, in this, the Honorable Trial Court has put contributory negligence on the part of the petitioner, please. Lord, I pray, my lord, to kindly refer the sketch here. Refer the sketch, my lord. Kindly refer the sketch.
We'll admit and list for final hearing, Mr. Counsel. You are Mr.
The
Lohit
records
M.
are already there, Madam.
it's
Can
here,
be
it's
disposed
here.
of.
Heard Sri Lohit M. Land Counsel for the appellant as well as Sri D. Vijay Kumar.
Contribution is only 10% negligence. It can be disposed of, my lord.
Yes, please proceed. Please proceed. Yes.
Yeah, please, madam. Lord, as per the sketch is at the end, is only 10%. There is no negligence on the part of the petitioner because he was almost crossing the road. Lost only 2 feet were left over. And moreover, the car was coming towards his right side, not on the left side. The car was coming on the right side. It's a U-shape, a semicircle. It's a semicircle, please, my lord. Lord, the second point is, my lord, functional disability. The doctor has given a functional disability of 16%, please, my lord. PW2, as PW2, he has appeared before the court and given evidence. And 16% is the functional
But the
disability.
nature of injury is sustained.
Lord,
It's a
as
hand
per
injury,
exhibit
wrist
P7,
to the wrist.
P7, you last week can see.
Huh?
Exhibit P7 is the wound certificate, my lord.
P7.
The simple injury.
No, it's a grievous injury, madam. To the right. To the left wrist, madam.
PW2,
Left wrist.
para 15, my lord, Dr. S.C.S. Omshekhar, he has stated, my lord. 31% to the limb and 16% to the whole body. My lord, in case of upper limb, my lord, 1/4 to be taken. The doctor has given totally
Yes,
false
what will
evidence.
be Before this court, huh? Globally, how much can be increased, Mr. Vijay Kumar?
Another 25,000.
Parent suffering 15,000 is grossly low. Loss of
It make it, my
ambulance
lord, 30,000.
My lord, medical expenses are not completely considered, please, my lord. Medical expenses not considered, notional income taken as 14,000.
Actually, we have calculated on the many occasions this matter come up before the court. My lord, I'll kindly go to para number 21, my lord, tabular form of the compensation. My lord, loss of future income, my lord, 2,60,442, maybe enhanced to 2,79,000. Then, my lord, pain and suffering instead of 15,000, 30,000. Conveyance, food, nourishment, my lord, they're the same, my lord. Even medical expenses is also the same. And my lord, loss of amenities, my lord, 25, tribunal has awarded 25,000. If you ask me, make it 30 or 40.
Loss of amenities, tribunal awarded 15,000.
15,000. You will ask me, make it 30 or 40, whatever. So you feel just unreasonable. And loss of income during the period of treatment, my lord, 14,000, so 469 is awarded. You will ask me, kindly make it 31,000. My lord, accident is of the year, my lord,
22.
22, my lord. The notional income may be
Increase would be 70,000 around.
that we have agreed and
Mostly.
so kindly proceed to pass orders.
Only one thing request to be added, please, my lord. Future medical expenses, she has to get the rod removed.
What medical expenses you have incurred till now? Huh?
That
No.
is also
Yes,
not completely
we'll increase
considered.
Globally by 70,000.
Please, madam.
And that is also not been completely covered. 20,000
Please, madam.
bills is not considered. 20,000 bills is left over. There are two bills. One is outpatient bill, another is inpatient bill. Total inpatient bill was 80,000 rupees. He has claimed the insurance and 20,000 was not given. Insurance company will not give any consumables like gloves, all those things will not be given.
Well, gave 19,255 towards.
That
That is
is only
outpatient.
same amount has been granted.
That's
Because
as an outpatient bill. After discharge, she has taken outpatient.
please, my lord.
What is your contention in this regard, medical?
My lord, what tribunal has rightly calculated what is the amount claimed and what is the amount has been reimbursed. And the balance amount tribunal has.
My lord, in this, I pray, my lord, to kindly refer exhibit number P18, please, madam. There is a medical.
Mr. Counsel will admit and list for final hearing.
My lord, you'll ask me make it 80,000 and close it, my lord.
Order.
Paper publication.
So Lohit M.
Yes, yes. One paper publication I have.
Will not get more than that, Mr. Counsel.
Please.
Mr. Vijay Kumar is gracious. Heard Sri
Please,
Lohit
madam.
M. Land Counsel for the appellant, as well as Sri D. Vijay Kumar, Land Counsel for respondent number 1 insurance company. Next, dissatisfied with the amount that is awarded as compensation. The claimant is before this court, challenging the order that is rendered by the Motor Accidents Claims Tribunal, Bangalore, in MVC 3941 of 2022, dated 28/11/2023. Full stop. Next, on the ground that she sustained grievous injuries due to the accident, the appellant filed a petition claiming compensation. Full stop. The tribunal, through the impugned order, awarded a sum of rupees
3,39,000.
39,166 as compensation, divided under following heads, A to A. Full stop. Sri Lohit M. for appellant submits that the appellant sustained grievous injury and was hospitalized for considerable period. Full stop. she produced sufficient proof with regard to her occupation and earnings by the date of accident. Full stop. However, the tribunal, without considering the proof produced by way of evidence, awarded meager sum as compensation and under all heads, which is unjustifiable. Full stop. Land Council thereby seeks for enhancement of compensation. Full stop. The submission that is made by Sri D. Vijay Kumar, Land Council for respondent number 1, on the other hand, is that the compensation granted is highly justifiable. Full stop. Land Council submits that, taking into consideration the totality of the facts and circumstances of the case, the tribunal awarded compensation. Full stop. However, Land Council states that in case this court intends to enhance the amount, there may be marginal enhancement under the head pain and suffering, loss of amenities in life, and loss of income during later period. Full stop. Next page. It is not in dispute that the appellant sustained fracture of radius, bone. Full stop. Also, it is not in dispute that the appellant took treatment as inpatient for the said injury. Full stop. Having considered the injury sustained to the left upper limb, that is radius, PW3, PW4 assess the whole body disability as 16%. Full stop. However, the tribunal took the functional disability as 10%. Full stop. The observations made by the tribunal in that regard needs no interference. Full stop. The tribunal also took the notional income, also assessed the income of the appellant as rupees 14,469 per month and awarded a sum of rupees 2,60,442 as compensation under the head loss of future earnings. Full stop. The amount thus awarded is justifiable. Full stop. However, having regard to the nature of injury sustained, this court is of the view that a grant of compensation of rupees 15,000 towards pain and suffering is unjustifiable. Full stop. This court considers desirable to award a sum of rupees 30,000 under the head pain and suffering. Full stop. Thus, the increase in that on that count would be 15,000. The tribunal awarded a sum of rupees 15,000 under the head conveyance, nourishment, and attendant charges. Full stop. This court is of the view that a sum of rupees 5,000 is required to be increased under the said head. Full stop. Also, having considered the nature of injury sustained, this court is of the view that the appellant would not have attended her normal pursuits at least for a period of 2 months. Full stop. Thus, the loss of earnings during laid-up period is required. Thus, a sum of rupees 30,000 is required to be awarded under the head loss of earnings during laid-up period. Full stop. Thus, the enhancement under the said head would be 15,000. Full stop. Where we can increase.
In the case of loss of future income, please. Future income, the income has not been considered. 15,500 was the, as per KSL, Karnataka State Legal Service Authority. Chat 15,500 was the amount fixed, please, my lord.
When you have produced evidence with regard to your income, how can that be taken into consideration by the council? Then we'll record that with in consonance with the submission of both parties, 80,000 is awarded globally.
Anyway, your lordship has dictated, my lord.
But we are not getting 80,000.
My lord, there is a few.
How much it comes, madam?
In 13.
Also, this court is of the view that the appellant is entitled to a sum of rupees 30,000 towards loss of amenities in life. Thus, the enhancement in that regard would be 15,000, 50,000. Another 30,000.
Some amount may be awarded towards future loss of income, of future medical expenses.
Future, she has to get a rod
Land
removed from-
Council also submits that the appellant is required to undergo another surgery for removal of implant and she requires a sum of rupees 50,000 more for the said surgery, full stop. However, as there is no material on record to show that the
Exhibit
appellant
P8.
needs,
Exhibit P18 is produced, madam. It's a estimate given by the hospital, please, madam.
how much?
50,000.
50, huh?
Yes, madam.
The
Exhibit
Land
P8.
Council also submits that exhibit exhibit
P18.
P18.
Copy of estimation, please. madam.
Land Council also submits that exhibit P18 copy of estimation reveals that the appellant needs a sum of rupees 50,000 for removal of implant. Full stop. Having considered exhibit P18, having considered the submission thus made, this court is of the view that $40,000. However,
Since they have not spent, my lord, another 10 to 20,000 may be awarded.
Bed
however,
charges,
the contents of exhibit, this is P18, reveals that a sum of rupees 40,000 would be required for removal of implant. Full stop. Having considered these facts, this court is of the view that a sum of rupees 30,000 is required to be awarded towards future medical expenses. Full stop. Thus, the compensation which the appellant is entitled to, in addition to the amount that is awarded as compensation by the tribunal, is rupees 80,000. Full stop. Thus, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, through orders in MVC 3941 of 2022, dated 28/11/2023, is enhanced by rupees 80,000. The enhanced amount shall carry interest at the rate of 6% per annum from the date of petition to the date of deposit. Respondent number 1 is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. On such deposit, appellant is permitted to withdraw the entire amount.
But 10% contributed negligence, there is no negligence, please, my lord. She was almost at
That
the
we
edge of.
cannot now go into that.
No, my lord, as per the sketch, my lord. I pray, my lord, to kindly refer the sketch, please.
Regarding future medical expenses, no interest.
What did you write? The enhanced sum? The
80,000.
enhanced sum, except the sum awarded under future medical expenses, carries interest at the rate of 6% per annum from the date of petition.
This 10% may kindly be reduced to 5%.
We cannot, we
Madam,
cannot.
it was almost at the edge
Hearing
of.
matters, PL number 63, Shri Ashok N. Patil, Srimati Kavita H.C. for R1.
No representation on either side on. There was no representation even on 2/9/24. Hence, list both the matters on 23/9 under the caption for dismissal.
64, Srimati Kavita H.C. D. Vijay Kumar.
You have not filed wakalat.
My lord,
Mr. Vijay.
actually, yesterday only they actually for earlier, they have given only the synopsis copy. And yesterday we have collected the copy of the appeal memo and sent it to the insurance company.
No representation on appellant side on call. Sri D. Vijay Kumar seeks a week time to file wakalat for R2. Time as prayed for is granted. Stand over to 26th September.
My lord, one submission, my lord. Here what is happening is, the court is directing the advocates to take out the notice. So, and the advocate for the claimants, my lord, and many times, my lord, in spite of our repeated request, they say, I'll give now, then, like that only it is happening. My lord, we trying our level best, even sometimes they are also trying their level best. Somehow they forget and we will also forget. That's how the things are happening. And many times, my lord, in our absence also, courts are directing to issue notice to the concerned advocate. But many advocates may not know that I have been directed to take notice in that particular cases. And even after receipt of the copies, my lord, we will send it to the insurance company immediately. But my lord, sometimes the case is not registered in their register. Almost all the private companies, my lord, they don't, they have only branch offices and a regional office, but they have to get it registered from the main head office only, so that they have to make an assessment. So claimant has filed this appeal. What will be the probable compensation? Further, they have to make a budget. Lot of other procedures are there. Therefore, my lord, it is becoming difficult for us to file the wakalat. But however, my lord, most of the companies, they accept, provided if we promptly attempt the case and make our effort to contest the matter on merit. And
Actually,
they will,
the judges are also sometimes in a dilemma whether to send notice or to direct the panel advocates to take notice.
but
What
only
if
thing,
I-
my lord,
So
though,
saving of time.
though there is a list of panel of advocates, my lord, very few advocates, merely 40% or 50% of advocates are very regular. They will be following it, they will attend to the court, they will collect this thing and send it to them. And whenever the case is called, they will be present and make their best effort to safeguard the interest of the corporation. And many advocates, my lord, they are in the panel, they are not coming to the court at all. That is what the things are happening. We should not make any.
Mr. Counsel, what we can do, because you see,
65. Serial number 65, Shri D. Vijay Kumar.
My lord, I am for the appellant.
Yes.
It is a fake policy produced by the claimants, my lord, that we have taken specific contention. And we have proved also, but my lord, tribunal has not properly considered it.
Yes. Record received, no?
Yes, ma'am.
Yes, record received. Yes. Mr. Counsel, it appears the depositions are in Kannada language. Land Counsel Sri D. Vijay Kumar for appellant seeks time to file translated copies of the depositions and the documents over which he relies upon. Hence, stand over to. How many days you require?
15-20 days.
Hence, stand over to 21st October.
Much obliged.
66, Srimati Ramya. Respondent, sir.
For the petitioner, Your Lordship. Your Lordship, we have applied for an FSL report to confirm that the rider was under the influence of alcohol. The documents are not available at the moment. So I humbly request in Your Lordship to grant us 2 weeks time and we will be filing the necessary records, Your Lordship.
This is 2021 matter, ma. How
Yes, Your
now
Lordship.
you are receiving the FSL report and all?
We have applied for it, Your Lordship. 2 weeks time, Your Lordship.
You are Ramya.
My senior, Your Lordship.
Your good name.
Saurabha.
Miss Saurabha, representing Ramya HN, Land Counsel on record for the appellant submits that the appellant is required to produce additional evidence, seeks time. The appeal is of the year 2021. However, to give fair opportunity, time as prayed for is granted. List on 110.
Much obliged.
67, Srimati Suma. Shri Srinivas, yes, for R1 and R2.
That gets the appellant, there is a lot of translated documents to be filed because this matter is dismissed before the trial court.
Yes.
Hence 3 weeks may be given.
Srimati Suma K. Land Counsel for the appellant seeks time to file translated copies of the documents over which she relies. Hence, list on 22nd October.
68, the KV Naik.
Yes.
Claimant appeal for enhancement, case of injury, my lord.
Where is the other side counsel?
That side, Sri Shaila, my lord.
Yes, Mr. Counsel.
Shrishayla. Sir, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? Shrishayla, sir.
Yes, my lord, I appear for respondent.
Yes.
Date of accident, my lord. 11/3/2020, my lord. He was aged about 49 years. Working as a agriculturist and real estate.
This is a case of death.
Injury, my lord.
Injury.
Injury. 11/3/2020 accident, my lord.
Yes. What are the injuries sustained?
My lord,
by-
injury sustained, my lord, page number 11, para 15 of the judgment, my lord. Exhibit P5 wound certificate and also exhibit P8 discharge summaries, my lord. Sustained head injury, my lord, page number 11, para 15 of the judgment, my lord.
Yes.
Head injury, right leg grade 2, compound fracture, lower 1/3 tibia and fibula, my lord. But he was a agriculturist and real estate work, my lord. He was earning as rupees 50,000 per month, my lord. My lord, the PW2 doctor assessed the disability, my lord. 45% limb disability and 15% whole body disability, my lord. The tribunal is considered only, my lord, 7% disability, whole body disability, my lord. The income is considered, my lord, 14,000 rupees, my lord. My lord, he was producing here, my lord, exhibit P16 RTC, my lord. 8 RTC, my lord. He was agriculturist. In the standing of the RTC, my lord, name of the injured, my lord. 2 acres, my lord. And also, my lord, exhibit P10 LME driving license holder, my lord. But income is considered 2020, my lord, 14,000 rupees, my lord. And it's a very lower side, my lord. My lord, disability, my lord, doctor assess, my lord, 45% limb disability and 15% whole body disability, my lord.
Kindly see, my lord, photograph, my lord, exhibit 14, my lord. And see the photographs, my lord. The disability is considered only 7%, my lord, is very lower side, my lord.
He is not a treated doctor. The fracture is united.
As a treated doctor, my lord, is a medical expert, my lord. As a 1/3 disability, my lord, 15%, my lord. 45% limb disability, my lord. Lord, para number 15 of the judgment, I maybe read it, my lord. Para 15, my lord.
Yes, yes.
My lord, as per the discharge summary, the petitioner was treated at Navachetana Hospital with wound debridement and open reduction and internal fixation with LCP and screws on 11/3/2020 and later discharged on 18/3/2020. During his follow-up after 8 months, he developed infection, hence he got the implant removal done and cost was applied at Sri Sai Prasad Multi-Speciality Hospital. PW2 doctor, the petitioner complains of weakness and pain in the right leg, unable to walk normally, unable to sit down, squat, and sit cross leg. On examination, he has unhealthy scar over the lower third of the left leg and restricted right ankle and knee movements. Malad, restricted right ankle and knee movements. Malad.
Yes.
The recent X-ray shows united fracture of the right tibia and fibula. The petitioner has examined clinically, radiologically to assess the disability. PW2 further stated that as per the disability assessment, petitioner physically disability of the right lower limb 45% and whole body physical disability 15%. In cross-examination, PW2, it is the brought out that he is not a treated doctor. The fractures are united. 45% limb disability, 15%, 1/3 of the disability, 15%. The tribunal is considered only 7%.
Yes.
Fracture.
Yes, Mr. Counsel. Yes, we have gone through the record. Yes, Mr. Sri Shailam, what is your submission?
Kindly see the photographs, exhibit P14.
They cannot, photographs cannot depict the disability. Yes, let us see, let us.
Please, please.
Yes, Mr. Counsel.
Sir, Matadi, sir. Srishailash, sir.
Yes, my lord.
Sir, ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
ತುಂಬಾ ಮೈಲ್ಡ್ ಆಗಿ ಕೇಳಿಸ್ತಾ ಇದೆ. ನಾಟ್ ಆಡಿಬಲ್.
ಮಾತಾಡಿ.
ಸ್ವಲ್ಪ ವಾಲ್ಯೂಮ್ ವೆರಿ ಮೈಲ್ಡ್.
Make your submission, Mr. Counsel.
Yes, my lord. Para 16, my lord. My learned friend read para 15. Continuation, para 16 may kindly be read. He is not a treated doctor and he says fractures are united and the learned tribunal member has clearly said functional disability doctor has not stated at all. Doctor has not stated, not spoken anything about the functional disability of the petitioner and 15% whole body disability stated by PW2 appears to be on the higher side. Having regard to the nature of the injuries, the period of treatment he has undergone, his functional disability may consider at 7% is a whole body.
Yes.
Tribunal has given reasoning for that. He is not a treated doctor and functional disability not stated. Tibia and fibula are the fractures and implants are also removed.
Yes.
And the complaining is he has got weakness in the leg. He cannot sit and squat. There is a normal, every person who suffers leg injury says. And particularly after 40 and 50 years, even I have knee problem. That is there. I cannot sit and squat. Little difficulty will be there. So tribunal has taken rightly at 7%. And he is an agriculturist and income not proved. In spite of that, tribunal has taken as per local guidelines. They are taken properly 14,000 rupees. I don't find, my lord, there is any discrepancy in this thing, in the reasoning. And one, my lord, pain and suffering, less is awarded. I fairly submit. Pain and suffering, only 20,000 is awarded. Your lordship may enhance it.
Yes.
Normally, this court grants 40,000 rupees.
Yes.
One submission, madam.
Normally, in every case, we have
Operation
been
is open
attending.
reduction, internal
Normally,
fixation,
40,000
madam.
rupees is granted in fractures, tibula, fibula. 20,000 is granted. That may be enhanced to.
Yes, Mr. Counsel.
And restricted right knee and knee movements, my lord.
Yes.
He was impatient for 8 days hospitalization, my lord. But pain and suffering is only 20,000 is granted in lower side, my lord. Loss of immunities 20,000 is lower side, my lord. Incidental attendance charges, conveyance, if you only 15,000, my lord. My lord, loss of earning laid off period, 1 month is granted, my lord, of 14,000, my lord. My lord, future loss of earnings, my lord, 7% is considered tribunal, my lord. It's very lower side, my lord. Totally 6,09,200, my lord. All the aids, my lord, increase the award, my lord.
Yes. Third. Sri K.V. Naik, learned counsel for the appellant who appears physically before this court. Also heard Sri C.H-25 S, learned counsel who represents respondent number 3 and appears through VC. This appeal is directed against the order that is passed by the Motor Accidents Claims Tribunal, Bangalore, in MVC 1872 of 2020, dated 6/8/2021. Full stop. This is a claimant's appeal. Full stop. The tribunal, through the impugned order, awarded a sum of rupees 6,09,200 as compensation, divided under following heads, A to A. Next, arguing the matter, Sri K.V. Naik for appellant submits that the appellant, besides sustaining a head injury, also sustained grievous injury to his right leg. Full stop. The appellant took treatment as inpatient for more than a week and underwent surgery. Full stop. PW2 clearly deposited that the disability in respect of right lower limb is 40%, and in
45%.
respect of 45%, and in respect of whole body is 15%. Full stop. However, the tribunal took the disability in respect of whole body as 7%, which is improper. Full stop. Learned counsel also states that the appellant, as an agriculturist, was earning rupees 50,000 per month. However, the tribunal took his notional income as rupees 14,000 per month, which is unjustifiable. Full stop. Learned counsel thereby seeks to enhance the compensation. Full stop. On the other hand, the submission that is made by Sri C.H-25 S, learned counsel for respondent number
2.
respondent number 2, respondent number 3 is that the appellant has not produced any evidence with regard to his occupational earnings by the date of accident. Full stop. Learned counsel also states that PW2 did not speak about the functional disability. Full stop. Having considered the nature of injuries sustained, the tribunal rightly took the functional disability in respect of whole body as 7%. Full stop. Learned counsel further submits that the amount awarded as compensation under all heads is justifiable, and in case this court intends to enhance any sum, it may be for the pain and suffering. Full stop. Next one. On going through the relevant material that is brought on record, this court is of the view that the assessment of disability as 7%, the assessment of functional disability as 7% in respect of whole body by the tribunal is justifiable. Full stop. PW2 is not the person who treated the appellant.
Full stop. Also, PW2 stated that the fractures are united. Full stop. However, you remove. Coming to the aspect of earnings of the appellant by the date of accident, the appellant produced exhibit P16 extracts, RTC extracts as well as P11 bank account statement to establish his occupation. Full stop. However, as rightly observed by the tribunal, the said documents does not establish the income of the appellant in clear terms. Full stop. There is no convincing material on record to show that the appellant was earning rupees 50,000 per month through agriculture. Full stop. However, considering the fact that the appellant was an agriculturist by the date of accident, and also in the light of the documents produced in that regard, this court considers desirable to take the notional income of the appellant as rupees 16,000 per month. Next, it is not in dispute that the appellant was aged about 49 years by the date of accident. Thus, the appropriate multiplier to be applied as per the decision of the Honorable Apex Court in Sarla Verma's case is 13. Thus, the compensation which the appellant is entitled to towards loss of earnings due to permanent functional disability is as under. Notional monthly income 16,000, annual income 1,92,000, apply appropriate multiplier 13, 24,96,000, 7% being permanent functional disability, loss of future earnings 1,74,720. Next. It is an admitted, it is clearly brought on record that apart from sustaining head injury, the appellant sustained compound fracture of lower 1/3 of tibia and fibula, and he underwent wound debridement and open reduction and internal fixation with LCP and screws. Full stop. Having considered the nature of injuries thus sustained, this court is of the view that the appellant is entitled to a sum of rupees 50,000 under the head suffering. Full stop. Also, the appellant is entitled to a sum of rupees 20,000 towards attendant, conveyance, food and nourishment charges. Full stop. The appellant, in the light of the injuries sustained, would have taken bed rest at least for a period of 3 months. Full stop. Thus, the loss of earnings during laid-up period comes to rupees 48,000 within brackets 16,000 into 3. Full stop. Thus, the compensation which the appellant is entitled to under different heads is as under. Compensation for pain and suffering 50,000, medical expenses 3,87,298, loss of income during laid-up period 48,000, loss of future earnings 1,74,720, loss of amenities 20,000, towards attendance, attendant, conveyance, food and nourishment charges 20,000. Add all those things. Good stuff. Thus, in the light of the foregoing findings, the appeal is disposed of with the following order.
Future prospects.
The appeal is allowed what future prospects? For 7% disability. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal Bangalore through orders in MVC 1872 of 2020 dated 6/8/2021 is enhanced from. What is the distance?
ಶ್ರೀಶೈಲ ಸರ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇದೆ. ಮ್ಯೂಟ್ ಮಾಡಿ ಸರ್, ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇದೆ.
ಹಲೋ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ, ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇದೆ.
The compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, through orders in MVC 1872 of 2020 dated 6/8/2021 is enhanced from 6,09,200 to so and so amount. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition to the date of deposit. The third respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. On such deposit, the appellant is permitted to withdraw the entire amount.
Much of, my lord, how much enhanced, madam? Total? I could not hear.
You will get the order, Mr. Counsel.
Yes, madam.
Over.
16 and 17 urgent.
Court officer? Court officer?
ತುಂಬಾನೇ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇದೆ ಸರ್ ತಮ್ದು. ಮಾತಾಡ್ತಾನೆ ಇದ್ದಾರೆ, ನಾನು ಮ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದೀನಿ, ನೀವು ಮತ್ತೆ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ.
ಓ, ನೀವ ಮಾಡ್ತಾ ಇದ್ದಿದ್ದು?
ಸರ್ ತುಂಬಾನೇ ಡಿಸ್ಟರ್ಬೆನ್ಸ್, ಮೇಡಮ್ಗೆ ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ.
ಸರಿ ಸರಿ, ನನ್ಗೆ ಯಾತಕ್ಕೆ ಮ್ಯೂಟ್ ಆಗ್ತಾ ಇದೆ, ಆಟೋಮೆಟಿಕ್ ಆಗ್ತಾ ಇದೆಯಲ್ಲ ಅಂತ ನಾನು.
ಇಲ್ಲ, ತುಂಬಾನೇ ಇಲ್ಲಿ ಏನೋ ಮಾತಾಡ್ತಾನೆ ಇದ್ದಾರೆ, ನಿಮ್ಮ ಎಲ್ಲಿದ್ದೀರಾ
ಓ, ಸರಿ 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 ಸರಿ. ಮೇಡಮ್, ಎಷ್ಟು ಎನ್ಹಾನ್ಸ್ ಆಯ್ತು?
ಟೋಟಲ್ ಮಾಡ್ಬೇಕು ಸರ್ ಅದು.
ಸರಿ ಮಾಡಿ. ಓಕೆ.